The Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Please be seated. Well, for our first order of business this morning, I'd like to ask the clerk of the court to approach the bench for an admissions proceeding.
Thank you, Your Honor. I'm before you this morning with a preliminary motion to admit 10 new members to the bar of our court. Before making the motion, with your permission, I'll introduce our candidates.
Please do.
Would our candidates for admission please approach the lectern? All right. First, we have 3 of Judge Matheson's law clerks. Kira Cooney, a graduate of the Georgetown University Law Center and a member of the New York Bar. Lauren Roberts, a graduate of the University of Wisconsin Law School and a member of the Wisconsin Bar. And David Caliguire, a graduate of Harvard Law School and a member of the Massachusetts Bar. Then we have 4 of Judge Phillips's law clerks. Leah Travis, a graduate of the University of Colorado School of Law, a member of the Colorado Bar. Nathan Togger, a graduate of Stanford Law School and a member of the West Virginia Bar.
Alan Sumrall, a graduate of the University of Texas School of Law and a member of the New Mexico Bar. And Arik Ransom, a graduate of Harvard Law School and a member of the DC Bar. And last but not least, we have 3 of Judge Rossman's law clerks. Nicholas Smith, a graduate of the Arizona State University Law School, a member of the Arizona Bar. Graham Ambrose, a graduate of
Stanford Law School and a member of the Massachusetts Bar, and Paige Roth, a graduate of the University of Iowa College of Law and a member of the Minnesota Bar. Before I make the motion and administer the oath, are there any questions or comments from the bench?
No questions. Well, there's probably too many of you to ask each one of you a question. So I'll just ask the whole group one question. By show of hands, do you agree that the 10th Circuit is the best circuit? Good answer. You may proceed with the oath.
Would all members of the 10th Circuit Bar please stand and silently renew your own oaths? Please raise your right hands and repeat after me. I do solemnly swear or affirm.
I do solemnly swear or affirm
that I will conduct myself as an attorney
that I will conduct myself as an attorney
and counselor of this court
and counselor of this court
uprightly and according to law,
uprightly and according to law,
and that I will support the Constitution of the United States.
and that I will support the Constitution of the United States.
Congratulations.
Congratulations. You've made the best circuit even better. And you now may be seated, and we'll proceed with our arguments this morning. We'll be hearing 5 arguments, and our plan is to take a break after the 3rd case. So the 3rd case, let's see, what is the 3rd case? The 3rd case is Scholl versus Walgreens, and we'll take a break and then come back after that for the case Jiang v. City of Tulsa. So if you could all plan accordingly. We'll start this morning, though, with Fogel versus Shelter Mutual Insurance Company, number 24-1422. Counsel, you may enter your appearance and proceed.
Sorry. Good morning, Your Honors. Kelly Kafer on behalf of the Appellant, Shelter Mutual Insurance Company. May it please the court. I'd like to try to reserve 3 minutes at the end of my argument, if possible. This case presents a question of an insurer's obligations under Colorado's Auto Policy Disclosure Statute, Section 10.3.1117. Very simply, the interpretation of a statute advocated by Mr. Fogel and accepted by the district court imposes a disclosure obligation on Shelter and other insurers that is clearly beyond what is set forth in 10.3.1117 and would punish them via significant statutory penalties for not complying with a standard that is not actually established by the statute. That result would be contrary to fundamental principles of statutory interpretation, as well as basic notions of fairness and equity, and should be rejected by this court. The district court, in essence, interpreted 10.3.1117 as requiring auto insurers to disclose any policy naming or insuring the alleged at-fault party, regardless of whether that policy actually or even potentially provided coverage for the loss.
What's the harm in that when it has to be kept confidential anyway?
I mean, the harm, Your Honor, is that, this is basically a situation where, the legislature has imposed this obligation on insurers and says, here's the language we're giving you. We're saying you need to disclose every policy that is or may be relevant. Insurers, attempt to comply with this in good faith, and disclose policies that they reasonably believe are applicable. In this case, it disclose the policy that did apply to the loss, and then, come back and say, well, it's actually broader than what you think it is. And so now you're subject to, in this case, about a year's worth of penalties plus attorney's fees, when you dispute that interpretation. So I think the problem is, it kind of goes to an issue of notice to insurance companies of, if you're going to say you need to be disclosing these things, I think you need to make the requirement clear if you're going to also be saying, okay, and now you're going to be penalized under the law if you don't do that.
How should we be, it seems like on the text, it's really about what may be relevant means. Do you agree?
I agree. I mean, that's the key turning point here.
And how, what is your analysis of that language?
I mean, I agree. I understand the language is obviously there's a dictionary interpretation, but then the problem becomes, okay, so I think the district court's reading of it was something that has a significant and demonstrable bearing at the matter at hand, which I don't necessarily disagree. That's the dictionary definition. The problem becomes, what does that mean when applied to insurance policies? And I think you have to look at it in the context of a statute. It can't mean every policy, because if it meant every policy, you just don't need that language. It could just say you have to disclose every policy of the insured. Obviously, it has to be something less than that. So then we think that the logical way to look at that is to say what applies? What does this coverage provided by this policy actually apply to this loss? Because that is kind of the, obviously the key point with regard to insurance policies is whether or not.
What work is to the claim doing in the statutory text?
I'm sorry, Your Honor, what was that?
What work are the words to the claim? So it's maybe relevant to the claim.
Yeah, I mean, and I think that's exactly the issue, is every claim is going to be fact specific, and those facts are key in determining whether or not a policy is going to apply to it. Like this case is one where, the insured had 4 different policies, each insured a different automobile. The fact of which vehicle was involved in the claim was key to determining which policy actually applied to the loss. So I think that also goes to the point of saying, like, if it has to be something that takes into consideration the actual terms of the policy, the actual facts of the loss, to say what is or may be relevant in this particular instance.
Counsel, does the statute say anything about who decides whether a policy may be relevant?
It doesn't expressly, Your Honor, but I think the way the statutory scheme works, it's essentially, I think, implicit that it has to be the insurance company. I mean, they're the ones who have the disclosure obligation under the statute. They're the ones who suffer the consequences if they get it wrong. And this was actually something that the district court addressed an oral argument on this in the transcript. She basically said that, looking at the statutory scheme, it appears that if the legislature wanted to impose a kind of turn it all over approach so that they just have to turn over every policy, they could have done that. They could have just said disclose every policy, but they didn't do that. So then it puts it in the hands of the insurance company as the disclosing party to make that relevance determination.
How is that consistent, though, with the legislatively stated policy of transparency? In other words, why should it simply be up to the insurance company to decide whether a policy is or may be relevant? Isn't it more transparent to broaden that issue and have someone other than the insurance company make that determination?
I mean, always could be more information you give. I guess there's an argument that's more transparent, but I don't think it's to say that the idea of having insurance companies disclose the policies that they reasonably do apply is not transparent. I mean, I think this has to be looked at in what.
How can if they're just making a determination back in the office that this can't be relevant, how's the statute enforceable?
Well, I mean, if you're not just, claimants are generally going to know if there is some policy that is out there because of things like police reports, and there's other tools that are out there in the world to discover if there's an insurance policy. So if an insurance company is simply not disclosing any policy, there's usually going to be some back and forth with the claimant about why that is.
In this case, how did Mr. Fogel learn about the other policies?
He learned about them, to my understanding, from the insured's personal counsel. So that's the other thing I was going to point to, Your Honors. There is provision in the statute for the claimant to get information about what insurance is out there, what insurance providers the alleged tortfeasor has directly from that person. They do have a disclosure obligation as well under the statute. It doesn't carry with it the penalties that apply with respect to insurance companies, but there is a disclosure obligation on the insured party themselves as well.
And what's the test for that? Is it an is or may be relevant?
No, there's no language about is or may be relevant. It just says that they.
Why would they need to disclose the three policies we're talking about here?
I don't know that they necessarily needed to, but they did. They provided information about the policies.
I thought I heard you say they needed to.
No, they need to identify my understanding of the terms of the statute is that they need to identify, I think, each company that provides them with auto. It's not worded exactly, but they need to provide.
On the covered auto, though, right? I mean, you're in an accident, you trade insurance cards, it's the insurance that applies to that car, but maybe they have policies on something else. Do you have to disclose all of that?
I think that's arguable. I think the statute is not that clear in regard to the disclosure obligation to the insured. It says that they have to identify their insurance carriers.
All right, but Mr. Fogel got information on all four policies and asked to look at them, and the company only provided the one.
He had the copy of the one policy, which is identical to the other policies, save for the declaration pages,
But
yes.
he was only provided the one policy.
Correct, Your Honor.
Correct, and so he just needs to take the company's word for it. Is that what you're saying?
I mean, I think in terms of the disclosure obligation of the statute, yes. I mean, that is the way the statutory scheme is set up, is that the insurance carrier has the obligation to disclose.
So how did the district court get this wrong?
Because I think the interpretation is basically that they have to disclose every policy, but that's not what the statute says.
That
It says,
is what the district court said. It interpreted is or may be relevant. It didn't say every policy.
but basically the determination of what is or may be relevant is going to be every policy.
That's
Well,
your
it was
interpretation.
the named
Yeah.
insured and the property type, right? I mean, there was some limiting principle to what the district court identified.
Well, the property type is auto, and this statute only applies to auto. So realistically, I don't see how the district court's ruling is not going to require disclosure of every auto policy that a carrier has issued to that particular person or names that particular person.
Do you agree that a claimant and an insurer could disagree in good faith and reasonably on whether another policy is relevant to the claim?
I think there could be a disagreement about that.
And so how does that not interfere with the ability to settle the case, which is another legislative policy?
Well, I mean, I think you have to look back to how, I mean, these things, there's historically, this disclosure statute obviously only came about a few years ago. I can't remember the exact year it was enacted, but before that, there was not an obligation to disclose any information. And it's very common for claimants to, as part of discussions with insurance carriers or the claimant themselves, or sorry, the at-fault party themselves, to, require, confirmation of what insurance coverage is or isn't out there before they enter any settlement. So there's always been, tools for people to get information and back and forth with these. That predates the statute. Could be dialogues between insurance companies. Now, if insurance companies are saying, yeah, I have this policy, but it doesn't apply, they're usually not just stonewalling. They're going to be giving some explanation of why, because, if they give an explanation, they're more likely to be able to either reach an agreement with that other party about why the coverage doesn't apply, or if there's obviously a disagreement that can't be resolved, it may have to go to litigation. But the statute, but there's always been ways for people to have communications and get information about these outside of the disclosure statute. And the issue with the disclosure statute, as we're saying, is, I understand you can have a debate about what the disclosure obligation should be, but this is a statute that not only sets forth a disclosure obligation, but also imposes very significant penalties on insurance companies for not, complying with what that disclosure obligation is. And what we're saying is, the statute clearly indicates that it should not be just every policy, that there has to be some limiting factor here, using the is or may be relevant language.
Is that solved by this court's opinion affirming, if the court were to affirm the district court? Now insurers know. We need to give up all the auto policies where you're an insured.
I mean, it would create some clarity going forward, but the problem is that I think is not fair to insurance companies that are left in this vacuum of the last few years, incurring liability for not disclosing policies they had no reason to think should be disclosed because they just didn't apply to the loss. I mean, there's never been a dispute in this case about these policies simply didn't apply. I mean, obviously, if there was, I can understand if there was a close question or some dispute on the facts about whether or not a policy applies, I think insurance companies should disclose it. If there's any question about, if there's some plausible way this policy could apply or some dispute about facts about whether it applies, they need to be disclosing it.
But
And
when
I think
you say that it might apply, and what is the data point for making that determination? I mean, the statute tells us that it has to be relevant to the claim. And I think I asked this question already, but I want to have a really clear understanding of what your position is on what makes something relevant to the claim.
I mean, the problem with that is it's going to be a fact-specific determination. They're going to have to look at, the terms of coverage and in relation to the facts. And if there's any dispute about the facts or the terms of coverage, again, I think that you have to err towards disclosure. But if there is certainty, like there was in this case, where, this policy only applies to these autos, these policies don't apply because it's this auto, there was no kind of disputes of facts where there would be a question. So if it's a clear case like this, I think that, the statute doesn't contemplate disclosure. But if there is any sort of, factual dispute or plausible way that the policy could come into play, then they need to err on the side of disclosure. And, they would be incentivized to do so because of the penalties that are imposed if they don't.
We haven't talked about damages, and I'm interested in whether you view the statute on damages as answering the question whether to award damages is based on a request for the policies or based on how many policies are requested.
I think it has to be based on, this is one particular claimant making requests for policies. Any and all policies that are subject to the disclosure of the statute have to be applied, and the most that can be awarded is $100 a day. I don't see how you can read the statute to impose more than that. I mean, if they wanted to do that, they could easily have included language to say, you're incurring a penalty of $100 a day per policy, per violation, whatever the term that's.
How do you answer, though, the fact that the statute uses the word policy in the singular? So if an insurer is asked to produce multiple policies, why wouldn't its failure to do so constitute multiple violations?
I'm sorry, say that again, Your Honor. If it's asked to request multiple policies?
Yeah, because the statute refers to policy in the singular. So Mr. Fogel asks for 4 policies.
Correct. But Your Honor,
Three aren't produced. Why doesn't the singular policy mean that there are 3 violations?
Because the obligation is to disclose all policies that apply, not just the policy request. I mean, the obligation is to disclose each and every policy that, is or may be relevant to the claim. So I think, it already assumes that the obligation to disclose one or more policies that apply. For instance, if there is an umbrella policy or something like that.
Does it say that? Does the statute say one?
Yes, it has language that says, with regard to each policy of insurance that is or may be relevant, that's the disclosure obligation. I'm sorry, Your Honors, if I'm out of time. I try to finish answering your question. But despite the fact that
Why
it
don't you
does.
just wrap it up and we'll be fine?
Sure, yeah, basically because it does contemplate disclosure of more than one policy already. I don't think you can read it to say that it also is going to impose a separate penalty with regard to each policy without specific language to that effect.
Thank you, counsel.
Thank you, Your Honor.
May it please the court, I'm Nelson Boyle here for Carl Fogel. So I would like to address a couple of things that were just said. First, that, there's always been ways to find out what coverage exists. I think my opposing counsel said. And if the legislature accepted that as true, they wouldn't have adopted this statute. The court can't assume that the statute was unnecessary. Also, I think I heard that certainly if there was some dispute over which policy applies, all of them would have to be disclosed completely. In the record, excuse me. Sorry about that. In the record, there was...
Counsel, that actually is a jumping off point for a question I wanted to ask you. I'm thinking of the timing issue here. I mean, we know, I take it in hindsight, that the three policies at issue weren't relevant, correct?
That's correct.
Okay. So if they weren't relevant, then why is there a violation of this?
So two reasons, and I'll get to the statutory language second. But first, in the oral argument, plaintiff's counsel was asked, how come this thing settled? And it was clear that it settled because there was personal counsel involved. And this is on pages 657 to 658 of the record, volume 3, where Mr. Smith, Mr. Fogel's counsel, explained that he had assurances from Mr. Catalano, the at-fault driver's personal counsel, that he still owned the vehicle on the one policy. If he did not still own the vehicle on the one policy, the other three policies would be in play. That conversation led to the settlement in November after the July 22nd letter that arrived. So getting to the language of the policy, or the language of the statute, my opponents, they seem to read the statute that just say is relevant, and they leave out or may be relevant. And, the definition of relevant comes into play there. It's, so it is significant and demonstrable bearing on the matter at hand.
So does
Or
relevant
maybe.
mean provides coverage?
No, relevant means that it could be relevant, it could provide coverage.
Well, what's the difference between provides coverage and could provide coverage?
Well, it's a policy that does insure this person, but may not apply to this crash.
And so that's the dividing line? If a policy names someone as an insured, additional insured, then you have to provide it?
Yes, or if they could be. I mean,
It
some
has to be
policies.
relevant to the claim. Right? I'm sorry to interrupt your answer to Judge Phillips, but could you incorporate that statutory language into your answer? I mean, that you're talking about that your opposing counsel is overlooking what may be relevant means. I think everyone is overlooking the to the claim piece of this. So how do we understand what may be relevant to the claim means?
So what may be relevant to the claimant is if there's coverage that may apply, because we all know that insurers and insureds sometimes get involved in coverage disputes, and this court and the court below and Colorado courts have to decide those disputes, where the insurer says, we read the policy to say you don't have coverage to their insured. And then the insured says, no, I think I do, and then a declaratory action is filed by one or the other, and the courts have to decide, what does this language mean? We cited some of those in our brief, I think on page 41, some cases that addressed that and said, the insurer got it wrong.
Could I just,
And so-
could I just back you up? Because I think what you just said relates to something that you mentioned a couple of minutes ago, which is if the policy that ended up providing coverage was based on the driver's ownership of the car, then the other three wouldn't provide coverage, correct?
That's correct.
But, so the question is, are the other three may be relevant in the event that the driver didn't own the car under the first policy? Is that what you're saying?
That's correct.
Okay.
And, if I could, I'd like to go to the damages portion of the case and address the question about whether it should be one penalty or three, if the court doesn't have further questions on the is or
I
may be.
actually do have
Okay.
another question on that. In the district court, the judge pressed you to articulate a workable standard, which I think is a challenging thing to do in this case. And I believe you said that it's something like if the tortfeasor is named on an insurance policy, then the policy is relevant because even if it doesn't provide coverage, he has to understand that it doesn't provide coverage. And I was thinking about that, and I don't understand how that's different than saying, well, disclose all the policies. And the statute doesn't say disclose all the policy. It has some limiting principle to it. So what is the workable standard that our court should find exists under the statute if we were to endorse your position?
Okay, so to clarify that, that's where do you draw the line
Where do you
before
draw-
all?
Well, what's the workable standard here that doesn't read the statute to disclose everything? Because it doesn't say that. And in fact, it seems that Colorado's statute's quite different from many statutes in other states that do require explicitly in the text broader disclosure. So what's the workable standard that endorses your position but doesn't read the statute contrary to its plain text to disclose all the policies, because it doesn't say that?
So that is a difficult question, obviously. I think that because it says may be relevant, it has to be every policy that may be relevant. It doesn't say all. I just don't have in my head a example of something that wouldn't fall under may be relevant. It's pretty expansive, as the district court recognized. I mean, the word relevant's expansive, but then may be relevant is even more expansive. And
The claim may be relevant to the claim. But so in your, if I understand your position, it's that the expansive, and I don't want to put words in your mouth, I'm just trying to understand your argument, that the expansive nature of that language may be relevant to the claim essentially should be read as everything, all policies.
essentially, yes, for the facts in this case. I mean, I imagine there may be a case out there that or, something out there that wouldn't fall within may be relevant, but I'm not sure what that is.
What about non-automotive policies? They wouldn't be relevant.
They would not, but the statute's pretty clear that it's only automotive policies. So I think it already carves those out. I guess if you had a situation where, maybe, somebody was insured under the household insured language in a policy and, say, they're the child of someone and then they move out to an apartment. And so they're now in an apartment, but their name is on the policy still because, they've gone off to college or whatever. Well, not to college. They moved out on their own and they are no longer within the household. There would be a household exclusion there. But again, I mean, I think they'd still have to disclose it because, you know, you wouldn't, the claimant wouldn't know that.
What about a policy purchased after the accident?
I'm sorry?
What about a policy purchased after the accident?
Yeah, policy purchased after the accident, you know, I think if they disclosed that the information that it was purchased after the accident, they wouldn't have to disclose the policy. I mean, you know, because they'd be able to show what this was, you know, there is a policy out there, but it was purchased after the accident. Here's the information from our system about when they purchased it. I think that would, you know, why would they have to disclose the actual policy then? That's maybe an example of where it's not every. Because, you know, but I'm not sure on that. I did also want to point out that the brief from the other side takes umbrage with considering the legislative purpose in section 10.3.1101 of the Colorado Revised Statutes. But in their, in one of their briefs at pages 426 to 427 of volume 2, they invited the court to look at that. And that was in the supplemental brief when the court asked for, you know, what does this language mean, you know, for them to address that. So it seems like they invited the court to do what they claim was error, to you know, consider the legislative purpose that's stated in the statutory scheme. On the question.
Damages? Are you going to talk about damages?
I'm sorry? Damages? Yeah. On the question about damages, you know, we believe that because it requires the disclosure of more than one policy, if there is more than one policy, and if each one is withheld, it supports the legislative purpose of transparency to have a separate penalty for each one. Also, there's a separate claim for each one in the lawsuit, and there should be damages for each claim. But
Well, let me jump in there. I'm not sure I follow that. I guess we've quoted the words "the claim" a few times this morning, and I think it comes into play again here because the request for the policies concerned the claim regarding this accident.
yes.
And if that's the way it works, why doesn't that show that any failure to produce them was a singular violation? In other words, you say, okay, we've had this accident, we're gonna make this claim, give us all the policies that are or may be relevant to the claim, then why isn't failure to do so a single violation? You only get a one-time penalty for that.
Well, if the insurer, say, here had withheld these 3 liability policies, but there was also an umbrella policy that they never disclosed at all and nobody ever knew about. And then in the course of the lawsuit on this, there was another policy that was discovered that also could be relevant. That would be, you know, I mean, so if they withheld the first 3 and then, you know, during the lawsuit you find out there's a 4th one, I mean, that'd be a separate incident because they didn't, you know, they didn't even know, you know, identify it.
Well, maybe, but still, the request was made. It was made in one day. Give us all the policies, and they held back the 3. I mean, the situation you're describing isn't what happened.
So in a situation, you know, these are $100,000 policies, but if you had, say, 3 umbrella policies, so it was $3 million in coverage, right? You know, the insurer would be incentivized to, even though there's a penalty, if the penalty is only going to be $30,000 or, you know, $100 a day for a year, you know, so $36,000, it would incentivize playing the game of, you know, do we just withhold these and see if anybody ever finds out about these umbrella policies? Because if somebody was catastrophically injured and they all applied, they'd have to pay $3 million. By having them have to pay for each policy that they don't disclose, it supports the statutory purpose. I'll also say that the statute is silent on whether it's, a course of conduct or each policy. But, each policy supports the statutory purpose. And the examples of other statutes that, the Colorado legislature had done this in, I mean, like the consumer protection one, there's a whole separate section of the statutes because they have about 100 different types of violations. Here, there's only one type of violation. So then they have that, and then the other one with the wage claim, if you read the sections together there, first there's an exception, and then they point to, Shelter points to an exception to the exception to say that, they used specific wording to say that there was a per claim, penalty available. But first they say that they are available, then they say they're not in a certain situation, then they say there's an exception to that.
Thank you, counsel. I believe we've exhausted the time for this argument, so we will consider the case submitted. Thank you for your arguments this morning. We will next hear Rogne v. City of Catoosa, number 255039. Counsel, you may proceed. Did I pronounce the
Rogne.
parties correctly?
Yes, Your Honor. May it please the court, Will Wright on behalf of Mr. Rogne. And we're here today because Mr. Rogne has not been given his constitutional right to just compensation, either under the Oklahoma Constitution takings provision, which is Article 2, Section 24, or the U.S. Constitution, Fifth Amendment takings provision. In 2011, the city came onto Mr. Rogne's property in the city of Catoosa, and with 6-foot rebar and an orange fence, took control and dominion over his property because they believed he needed a permit. The problem for Mr. Rogne was he had already gone to an administrative hearing and the city had already made a decision no permit was required. In the 2011 cease and desist order that was served on Mr. Rogne, along with the fence that was placed on his property, Mr. Rogne attempted to work out a resolution to no avail. In 2014, Mr. Rogne filed suit in Rogers County District Court. And I'll read to you just the statement, one statement he made. City of Catoosa has caused damages by way of inverse condemnation in excess of $10,000. The city of Catoosa has taken away the plaintiff's rights without compensation by prohibiting the plaintiff from entering onto plaintiff's own property without plaintiff's consent. The Oklahoma Constitution guarantees a jury trial. That is Article 2, Section 19. When you're asking for money damages, you are guaranteed a right to trial by jury under the Oklahoma Constitution.
What about statute of limitations?
Statute of limitations can be told under Oklahoma Title 12, Section 100.
And if not told here, then you would lose.
That's correct. Okay, so Title 12, Section 100 has been interpreted by this court to apply to a Section 1983 claim. So regardless of whether it's a constitutional claim, a liberty claim, if it's a Section 1983 claim, Section 100 in Title 12 is the savings provision. And the savings provision tolls the statute of limitations. The case that was pending in the state court did not complete until 2024 when final mandate came out. The tolling statute,
Can you say
and this
that
is an
again?
important point.
What happened in 2024?
That was the completion of the entire state action. So the state action went to state trial court. Then the state action went to the state court of appeals. And then there was a petition for cert to the state Supreme Court. The cert was denied. So interpreting the tolling provision of Section 100, you commence your second action if you have the right to refile your action, and the commencement date begins on the date that cert was denied.
And what is your argument for why you had the right to refile your action?
The tolling provision specifically does not address judgment, summary judgment, dismissal with or without prejudice. What the tolling statute, the text of the tolling statute says is if the action fails other than on the merits. And in our briefing, Mr. Rogne argues that the state action failed other than on the merits.
Isn't that contrary to what the Intermediate Court of Appeals said?
No, I disagree. The Court of Appeals said Rogne cannot maintain an inverse condemnation claim under any set of facts because he failed to exhaust his administrative remedies prior to filing the instant action.
But didn't the court also say as a matter of law there was no taking?
It did, it dropped a footnote.
How should we be thinking about that?
What was the basis? The basis was rescission. So you have no takings because you got the relief of rescission. That isn't what the U.S. Supreme Court interprets the Fifth Amendment. Just compensation is the remedy, not rescission.
Wasn't this an interpretation of Oklahoma takings law?
That is correct. In Oklahoma,
And
taking...
you think maybe that was wrong? For them to say there was no taking?
Yes, right or wrong, it's still not a decision on the merits.
Well, why not?
Because the decision was based on rescission. That was the underlying basis for the Court of Appeals decision. You got your relief.
Can you elaborate? When you say rescission, is it because the court said that there was no exhaustion of administrative remedy? In other words, that they hadn't got an administrative decision?
Well, it's confusing because on the one hand, the court says you failed to exhaust. And on the other hand, the court says you were granted relief because you did your administrative remedy. So on the one hand, we've got failure to exhaust, which is jurisdictional under Oklahoma law, and it's a lack of jurisdiction. If you fail to exhaust, it's lack of jurisdiction. Lack of jurisdiction is not on the merits.
What was the basis for your cert petition then? Weren't you challenged?
The mootness, we were saying you have jurisdiction. So at some point, Mr. Rogne has to get relief for just compensation under whether it's the Oklahoma Constitution or the U.S. Constitution. Just compensation is the remedy. He was not provided a remedy for his constitutional guaranteed fundamental right of just compensation. What the city argued in the state court, plaintiff exhausted his administrative remedies and prevailed. Because he was successful in obtaining a rescission of the CDO, that's the cease and desist order, the plaintiff's sole remaining claim is not judiciable. That's Article 3, no case in controversy. So the city in the state action was arguing there is no case or controversy. Your claim is moot. And under case law, both in Oklahoma, in U.S. Supreme Court precedent, and this court, a moot case is not a case on its merits. The city argued, and the state court agreed with the city and terminated the action. The action was terminated because plaintiff's inverse condemnation claim is moot. Those are the words of the city. The city argued to the state trial court, the plaintiff's remaining claim is founded on the CDO, which is the cease and desist order. The cease and desist order is no longer in existence. Accordingly, there is no longer a case or controversy for this court to decide. The plaintiff's claim is moot.
Well, so the district court dismissed on mootness grounds, endorsing the city's argument, right?
Agreed.
But then the Oklahoma Court of Appeals conducted a de novo review and concluded as a matter of law, under Oklahoma law, that there was no taking. And so it may be that the basis for that decision is something that you contest. But what we need to decide is whether that decision, not the mootness question, because that was not the basis of the Oklahoma Court of Appeals determination, whether the matter of law decision that there was no taking somehow gets you tolling because it wasn't a decision on the merits. And it seems to me that it is a decision on the merits with which you disagree.
The administrative remedy was rescission in the eyes of the Court of Appeals. Rescission is not on the merits of a just compensation. Mr. Rogne is here today because he has not been compensated to which he's entitled to. Every step of the way, which court has jurisdiction to hear his compensation claim? Which court? We're here today asking you
Well,
to allow him.
Counsel, what I think these questions are getting at is, what is the language in that footnote doing there then, if they say there was no taking? I mean, was it just a throwaway line? Is that what you're saying?
I agree.
Well, then what's it doing
Dicta,
there?
advisory opinion. What did the Court of Appeals actually do? They affirmed. They didn't reverse, consistent with our findings. They didn't do a finding of fact as to what a taking is. Appellate courts are not findings of fact. We don't make findings of fact in the appellate courts.
Well,
Oklahoma is consistent with this court.
Counsel, is the statement that no taking occurred a finding of fact? Isn't that a legal conclusion?
It's a legal conclusion based on an administrative remedy that had failed. It was not that, under Oklahoma law, in order to determine what a taking is, there has to be a finding of fact by a jury or trier of fact as to substantial interference. Do we have a record in any of the court where there was a finding of fact of substantial or not substantial interference? So I do agree that that was dicta.
You know,
I agree that it was an advisory opinion.
Well, what do you mean agree? I don't know who you're agreeing with. You're arguing that.
I'm sorry, Your Honor.
Let me ask you this. I thought one of your arguments was that you actually did challenge the no takings occurred conclusion in the footnote because the court didn't consider whether there was substantial interference with the property or just compensation. What happened to that argument?
Mootness was the issue that was appealed.
No, that's not what I asked you. You made that argument in your brief. You haven't said anything about it this morning. Are you waiving it? Have you abandoned it?
Which argument is that? I'm sorry.
The argument that the court didn't consider whether there was a substantial interference with the property. In other words, a temporary taking between 2011 and 2017.
Correct, they did not.
All right. So is that what your argument is about the no taking occurred, or are you saying that that was wrong because the court didn't consider that?
I'm
I'm just asking you what you put in your brief.
I understand.
Well, do you want to explain it then? How do you connect it to the note-taking occurred? I thought you were challenging the note-taking occurred because the court didn't do the analysis to get to that conclusion. Is that a misreading of your brief?
No, Your Honor.
Okay. And is that the argument you're still making?
There was a taking. That's the argument. That the footnote that was dropped was a, oh, by the way footnote, because what it is footnoting is he failed to exhaust his administrative remedies prior to filing the instant action. That was the holding, and it affirmed the judgment. And what was the judgment? The underlying judgment was not justiciable, no case or controversy. So if you're affirming mootness, you don't have jurisdiction or power, as Article 3 would say. You don't have power to make any other rulings under U.S. Supreme Court precedent under
Saying mootness in state court?
Church of Scientology. No jurisdiction to give opinions other than on any other questions. So if we're deciding that it's moot, then it's moot.
Well, who decided it was moot?
The district court?
Wait, the federal district court?
No. The state district court decided it was
Article
moot.
3 applies to federal courts. So is there what's the mootness doctrine in Oklahoma?
The city argued the mootness doctrine. Under Article 3, they argued federal application to the constitutional claim in the state court.
Well, whether it was right or wrong, my understanding of what the Intermediate Court of Appeals said is there's no taking because Mr. Rogne was granted relief as soon as he sought an administrative remedy and the city rescinded the cease and desist order. That's why no taking.
Did the Court of Appeals affirm mootness? If the Court of Appeals affirmed the judgment, the lower judgment that was decided that it had no jurisdiction, then there is no jurisdiction to make that decision.
What I just read to you, though, it
I-
said
it's in the
there's no
footnote.
taking because once you came to us with the administrative remedies, you got relief.
Rescission, not just compensation. They rescinded the bad act. Under Nick, the U.S. Supreme Court, rescinding of the illegal conduct is not a bar to a takings claim. That would be First English. They cited First English in the most recent U.S. Supreme Court case, and Delvilliers cited both Nick and cited First English, that rescission is not a bar. And so the basis for the state action was rescission. I'd like to reserve the rest of my time.
I don't think you've got more time. Are we over time? You've gone over your time.
Oh, I've gone over my time. I'm sorry.
That's all right.
Good morning, Your Honors, and may it please the Court. Allison Parker here on behalf of the City of Catoosa. I want to take a moment and go back through some of the history of the state court litigation because I think our timeline is confusing and that there are a few things that counsel didn't mention that might be helpful to your analysis. There were 2 cease and desist orders. One was in 2009. Mr. Rogne sought administrative remedy and got that rescinded. In 2011, another cease and desist order was issued by the City of Catoosa. Rather than seek his administrative remedy at that time, Mr. Rogne chose to file a lawsuit in state court. It wasn't until 2016, after the city filed a motion for summary judgment arguing failure to exhaust administrative remedies, amongst other things, that Mr. Rogne asked for a stay of that case, and he sought his administrative remedy, at which point he gained rescission. But now we're talking 6 years after the CDO was issued. So there is this delay between the CDO being issued and him actually deciding to seek his administrative remedy. And I think that delay informs the Court of Civil Appeals decision that there was no taking. I mean, can he self-create a temporary taking by failing to exhaust his administrative remedies? So that is important. Also, in the district court, the final order is based upon not only the city's motion to dismiss for a lack of a justiciable claim after the rescission, it was also based on granting a summary judgment that the city had previously filed in 2016. Mr. Rogne did not respond to that motion for summary judgment, and months had gone by since the stay had been lifted. So there were other issues that the Court of Civil Appeals could look at in their de novo review of the file in their decision. I disagree that the footnote is dicta. I think it is very responsive to one of Mr. Rogne's issues on appeal.
How's it necessary to the ruling, to the holding?
I think it was necessary to that appeal because one of the issues that Mr. Rogne raised on appeal is the same issue that he's raising today, that he was deprived of his constitutional right to get compensation for that temporary taking. And I think that prompted the court to say, well, we don't see a taking.
Could Mr. Rogne's complaint be read to assert a takings clause claim independent of the 1983 claim?
I don't think so. And this brings us to what happened with the Nick filing. While the state court case was proceeding, and during the course of it, the Supreme Court issued the Nick decision. And that decision did away with the requirement that you exhaust your state court remedies before you can bring a federal takings claim. That was in 2019. So at that point, Mr. Rogne could have filed a federal takings claim in federal court or otherwise amended his pleadings in the state court action. That didn't happen. So now, he wants to argue that it's going to toll from the conclusion of a state court case where he didn't have a federal takings claim alleged. So it's too late for the claim. He could have brought it in 2019, and under 10th Circuit law, a 1983 claim does accrue at that point when you are able to bring the cause of action. There is an issue raised on in Mr. Rogne's reply brief that I think you're getting at, Your Honor. And he cited for the first time on appeal a recently decided 11th Circuit case that states that you can bring independently from a 1983 action a claim, a federal takings claim, without going through the vehicle of Section 1983. That case was decided between the city responding on appeal and Mr. Rogne's reply brief. I don't think that case is at issue here. We have a pending motion to file a surreply. I don't think that Mr. Rogne pled a direct takings claim. All of his issues refer to Section 1983. And even if he were found to have that, I don't think the 11th Circuit case is precedential here because it, A, is the 11th Circuit, and in the Nick case, the Supreme Court refers throughout to the ability to bring a federal takings claim via 1983.
Could we just focus in on the savings statute and the reference in the statute to the words otherwise than upon the merits? Okay,
Of course.
So we've got that in the savings statute.
Yes.
Now let's go over to the Oklahoma State Court decisions. What was the merits question in state court?
I believe the merits question in state court comes up on that COCA de novo review from the Court of Civil Appeals in Oklahoma, where their decision is not only that he failed to exhaust his remedies, but also that as a matter of law, there was no taking.
Well, let's break those two things up. Let's say that he didn't exhaust his administrative remedies. If that was the ground for the decision, is that a decision on the merits?
I don't think so, Your Honor.
So do you need the footnote to succeed in this appeal?
In regard to statute of limitations,
Yes.
I do think that it addresses the statute of limitations argument, yes.
All right. Now, isn't the merits question on that whether the city substantially interfered with the property and failed to pay just compensation? They're saying, look, we couldn't use the property between 2011 and, 2017? But did the courts really ever address that question? Isn't that the merits question?
That is the merits question. And as part of the city's motion for summary judgment below, it had argued that there was no taking because it was a lawful use of the city's police power in this city ordinance that affected Mr. Rogne's property. So in the sense that the Court of Civil Appeals reviewed the entire record on its de novo review, that issue was in the city's brief, to which Mr. Rogne did not respond.
All right, but your position hinges on the no takings language in the footnote.
Yes,
At least on the statute of limitations.
as to that tolling statute, yes, section 100. Another reason that we believe the district court engaged in the correct analysis is that Mr. Rogne's takings claim is barred by issue preclusion as well, due to the footnote by the Court of Civil Appeals. Mr. Rogne addresses the factors required for issue preclusion in his briefing as requiring a decision on the merits. And that is incorrect under Oklahoma law, because this case involves a issue that was decided in a state court. The proper rule of preclusion would be the state court's rule of preclusion under 10th Circuit authority. And those factors are that it was litigated and determined in a prior action between the same parties, and resolution was essential to the decision in the prior action.
Could you address Mr. Wright's mootness argument?
The mootness argument that it does not constitute a failure otherwise than on the merits?
Well, the argument, yes, I think that's what. But there was an argument about this really was decided on a justiciability ground, not a merits ground.
Correct. The operative opinion, and this is where it gets confusing because counsel likes to go back to the trial court decision, but because it was a de novo review by the Oklahoma Court of Civil Appeals, that is the operative decision that we're working with. We're not looking at what the trial court did because we have the subsequent decision. And that was also what was reviewed by the district court in rendering its ruling in this case.
So did the Court of Appeals address mootness?
I don't recall, Your Honor, I'm sorry. I think their opinion was largely focused on his failure to exhaust remedies in I think, as Your Honors indicated earlier, this is not a situation in which Mr. Rogne has been prevented from raising these claims. And in fact, he could have brought a federal takings case at the time that the NIC decision came out. He has raised this issue, by my count, this is the 7th time. He just doesn't like the outcome. He raised it in the trial court in response to the city's motion to dismiss, he did a motion for rehearing. There was a motion for new trial. Then there was the appeal to the Court of Civil Appeals. Then there was the writ. And then he refiled this case. Are there any other questions I can answer?
Unless you have something else, I don't think we do.
I think we're okay. Thank you.
Thank you. Thank you, counsel. The case will be submitted. Counsel are excused. We appreciate your arguments.
Thank you.
We'll next hear Scholl v. Walgreens, number 255053. Counsel, you may proceed.
Your Honors, and may it please the Court, Jason McVicker on behalf of Jackie and Eric Scholl and JJS, a minor child. I intend to reserve 3 minutes for rebuttal, and I am going to refer collectively to our appellees as Walgreens. I want to start with a short recitation of the facts because JJS is a minor child who was adopted from China with a wide array of really serious health problems. Those include developmental delay, those include deafness, and of particular importance today is a diagnosis of vaginal agenesis. Put simply, her body cannot naturally clear menstrual fluid or tissue, resulting in an extremely painful internal buildup. And in Walgreens' brief, they say, well, she didn't die. That does not change the horrifying and painful nature of the injuries that she suffered as a result of Walgreens' failure to timely dispense this medication. Now, as you know, the family ultimately chose to manage vaginal agenesis using Lupron depot shots to suspend JJS's menstrual cycle. This prescription, for a variety of reasons, had to be filled by a specialty pharmacy. And what this case ultimately comes down to is what duty does a pharmacist owe a patient? Now, Walgreens, in its brief, sort of takes issue with the word patient, but as the court can see from the motion for summary judgment, to which was attached a patient assessment report and consolidated patient notes, it had no difficulty admitting that JJS was a patient below. I would also direct the court's attention to Walgreens' corporate representative's testimony, Catherine Cirencioni, who testified that she is both a pharmacist and an attorney, admitted in her deposition that JJS was a patient. She also, I think importantly, admitted in her deposition at page 38 that time is of the essence when filling these prescriptions. That can be found.
Could I just ask you, as I understand it, the duty question is presented essentially in two parts. One is whether Walgreens owes a duty to fill prescriptions under Oklahoma law. And the other is more of an as-applied kind of duty. That is, did Walgreens assume a duty based on what happened here to the plaintiffs through its actions?
I follow.
Does that work so far?
Yes.
Okay. So when you start referring to the record and these documents and deposition and so forth, which of those two are you talking about?
I think there's analytic overlap here because the district court departed from the arguments that Walgreens made, and so I think we need to talk about all of them together.
Well, that's fine, but it would also be helpful at some point to maybe pull out and because you are making two separate arguments.
Certainly, Your Honor.
Yeah. Okay.
The common law issue here, I think, is probably the simpler of the two issues. Under Oklahoma law, and again, we are talking about what the district court did in this case. Walgreens argues in its motion for summary judgment at pages 16 through 19. We satisfied our duty. We terminated our duty by following our internal policies and procedures, and then we did not reassume a duty, which I think is a pretty important admission there, until later. That is the argument that Walgreens makes in its motion. The district court took a third path by finding that there was no duty at all. And I want to start with the common law duty because I think it is clear error in this case. The Oklahoma Supreme Court in Wofford versus Eastern State Hospital declared that you have a common law duty anytime it is foreseeable that your failure to satisfy your professional obligations could harm someone. And if the question is simply, was it foreseeable that the failure to timely fill this prescription would injure JJS? The answer is clearly yes. Wofford is important for two other reasons.
When did the duty arise that you're describing? What moment?
When they accepted JJS's prescription as a patient. And I would direct the court to the patient assessment report and the consolidated patient notes attached to Walgreens' motion for summary judgment.
What, is that June 1 or 2?
Yes.
Why isn't it a conditional duty? If you get the pre-authorization, then we'll do X, Y, Z. But if you don't, good luck. It sounds like you don't want to use Walgreens anymore.
Well, I think that's a hypothetical question, Your Honor, because the fact is Walgreens did receive the pre-authorization number. I would also note, Your Honor, that in addition to the mere fact that there is a pharmacist-to-patient relationship, Walgreens represents to patients in general and to the Scholls in particular that they are going to do all of the work for this. This is a representation they make to all of their patients and a representation they made to Ms. Scholl.
So was there any limit, any time limit in getting the pre-authorization? It had been gone on for 3 months.
I think that would be negligent.
On whose behalf?
Certainly on Walgreens.
Okay. Do you think Walgreens could secure the pre-authorization and had a duty to do that?
Yes.
I thought the doctor had to get it.
Well, again, that's not what Walgreens tells patients.
Well, but isn't that what Walgreens told Dr. Hildebrand?
It is.
Well, then isn't that where the responsibility was for pre-authorization?
I think you could make an argument that there is a form of ghost tortfeasor liability or comparative negligence there, but it does not negate the pharmacy's own duties. Again, Wofford, I think, governs here, because Wofford makes the important holding.
Wofford a pharmacy case?
No, Your Honor, it's a psychiatry case.
What does it have to do with pharmacies?
Two things. First, it says, as a matter of Oklahoma Supreme Court precedent, that there is no rational basis for insulating any particular professional calling from liability for negligence occurring in its performance. It also explicitly rejects the district court's conclusion.
Where is the discussion of duty, though? I mean, you don't get to negligence without a duty. Where's the duty in that?
In Wofford?
In the statement that you just quoted.
The question in Wofford was whether or not a psychiatrist owed a duty of care in discharging a psychiatry patient who could be a danger to others. Similar to the terror.
Like a far cry from a pharmacy getting a request for a prescription and needing pre-authorization.
I disagree, Your Honor, because...
There's no factual distinction between those two scenarios. Is that what
No,
you're telling us?
I think you can form factual distinctions, certainly. But what the Supreme Court says is two things here that are relevant in Wofford. The first is there's no rational basis to just say pharmacists don't have a duty. That is not a holding that the Oklahoma Supreme Court has ever made. Separately,
Well,
Wofford...
on the first issue you raise, that was the holding of the district court, that under the Pharmacy Act and the Pharmacy Board regulations, there is not an express duty to fill. So we're back to that issue, unless you want to revise that statement.
No, Your Honor. I think we're still on that issue, and I want to...
On what issue?
On this issue of duty.
I thought we were on common law issue. Isn't that what you wanted to talk about with Wofford?
Yes, Your Honor.
Okay, the statement you just made sounded a lot more a statement, a general statement about Oklahoma law on the duty to fill prescriptions by pharmacies. And this is my problem with your arguments. You seem to toggle between the two, and you've got to give us an analytical distinction to understand what you're saying.
Wofford answers this question. Is it foreseeable that the pharmacy's failure to fill this prescription could injure JJS? Wofford also explicitly rejects the district court's...
Based on a case that has to do with a psychiatrist-patient relationship?
Yes. Here we are presented with a case where there is a pharmacist-patient relationship. And Wofford recognizes...
That's the same as a doctor-patient relationship?
No. But Wofford recognizes that these...
If it's not the same as a doctor-patient relationship, why does Wofford control?
Wofford says that regardless of the distinctions, because Wofford deals with this...
Regardless of the distinctions? I mean, you need a case that's on point. You don't have an on-point case. Give us a pharmacy case. Do you have one?
No, Your Honor.
All right.
Well, that's not accurate. I think Cavalli addresses this from the Fifth Circuit.
Okay. All right. You have an applicable state law case that talks about the pharmacy duty.
No, Your Honor, but I think that you are drawing the question at a level of abstraction that is not consistent with Oklahoma
I'm drawing
law.
the question at a specific to pharmacies. It's not abstract at all.
Under Oklahoma law, you owe duty as a professional anytime it is foreseeable that your negligence could harm your client, your patient.
Regardless of the profession.
That's an abstract statement.
Is that your position?
Yes, Your Honor.
So all of these cases that you are relying on that don't deal with pharmacists, it's your position that they're still relevant because there's a general professional duty recognized in Oklahoma. Is that your position?
Exactly. And this court, interpreting Oklahoma law, agreed in McGee versus Forest Oil Company. This is a general negligence principle. This is a common law duty.
That applies regardless of the profession?
That is correct.
Okay. Go ahead.
I didn't mean to interrupt.
No, you go ahead. Go ahead.
I would also note that the authorities that the district court and Walgreens rely on are non-precedential opinions of the Oklahoma Court of Civil Appeals, one of which is not a negligence case and does not purport to address tort duties.
So let me, I want to redirect you. If, as Judge Matheson pointed out, we have these two buckets, the duty under Oklahoma law and the course of conduct. Let's assume that we disagree with the argument that there's a general professional duty in Oklahoma that would apply here in favor of your position. And what's left then is there has to be some duty from Walgreens' course of conduct, right?
Yes, Your Honor.
Okay, focusing just on that, that then requires us to look at what the evidence was at summary judgment, right?
I agree.
Okay, so what exactly is the evidence that we should be looking at here that Walgreens promised anything, made a contract, took on a special relationship before July 13th?
I would direct the court to several places. I think the most salient testimony can be found in Ms. Scholl's deposition at Appendix Volume 3. In the passages, the deposition pages are 174 through 176, and that's at the Appendix 148. I would also direct the court to Walgreens' corporate representative's deposition testimony, where she admitted there was a duty to timely fill a prescription. At deposition page 43, Appendix Volume 3, page 69. I would also direct the court's attention to the promises made to patients that Walgreens attached to its own motion in Appendix Volume 4, page 41. Additionally, Your Honor, one of the complaints that we have about the breach of contract...
Can I just ask you, of all the sites that you just gave us, what's the answer to Judge Rossman's question about what happened here, the course of conduct? Could you elaborate on any of those testimonies?
Walgreens told this patient that they would fill the prescription when they got the pre-authorization number. They got the pre-authorization number in June. They didn't fill the prescription. I would also note here that this court's review is de novo, and applying common sense to these facts, look at that patient chronology that Walgreens attached to its own motion. When Jackie Scholl called the pharmacy and said, here's the pre-authorization number, they told her they would fill it. Now, the district court, sua sponte, declares that, well, we don't know what happened in that call.
Is that on June 16? Isn't that when they got the pre-authorization?
In June, yes, Your Honor.
June 16.
I believe that's accurate.
Okay, I think it is, but if we're off a day, it doesn't matter. What is the evidence that when they got the pre-authorization number, and I thought Dr. Hildebrand communicated it too, didn't she?
That is correct, Your Honor.
Okay.
Separate phone calls, but same day.
Okay, two phone calls. What is the evidence at that point that Walgreens said, okay, we're going to fill the prescription? What does the record tell us there?
This ties into two issues, and one is, from the record, again, common sense. What was this family supposed to
No,
do?
you just said that they said they were going to fill a prescription. Is there anything in the record that supports that on June 16?
Yes, Your Honor.
Because they'd already closed the file.
Well, yes, they did. Here's the thing.
Now, I just want to know, what's your evidence?
The record reflects that the file closure was not communicated to my client. When my client communicated with Walgreens, they told her that they would fill this prescription.
Okay, what's your evidence of that? That's what I'm getting at.
Yes, Your
Can
Honor.
you pin
And
that down? If you
I'm
got a
trying to
record
answer.
site, I'd love to hear an answer.
When you look at those patient notes, there is no rational explanation for the gap between June and July, except the fact that my client was led to believe by Walgreens that the prescription was going to be filled.
Is there a
This-
record and a page site, and here's what it says on that page? That's the question.
Well,
And if
this
you
is-
don't know the answer, then say you don't know the answer.
Your Honor, this is leading into my second complaint about the district court's sua sponte decision.
All right, you're over time, and you can keep going for a little bit, but
I appreciate that, Your Honor.
let's get to the point.
One of the arguments that we have raised on appeal is that if this argument that we had to enter into a separate contract with Walgreens after the pre-authorization had been provided, an argument that Walgreens did not raise, that the district court raised sua sponte, we would have submitted an affidavit from Ms. Scholl. This is something that Walgreens didn't raise, it wasn't part of their motion, and it was so unimportant to Walgreens that they didn't ask about it in her deposition.
So
If
is
my-
just to clarify, is your answer then to the questions, point us to a record site, that there is no evidence, and that's because you were not on notice that you needed to develop this evidence?
That is correct, Your Honor.
There is no evidence, and so this connect, just so that I understand, that this connects to your allegation of error on the sua sponte ruling.
And
Is that right?
that is exactly correct. And absent that, I am relying purely on circumstantial evidence that is in the record. But I'm not going to tell you that circumstantial evidence is not different than direct evidence. That's a fair point.
Thank you, counsel. Appreciate the explanation. I think we got to where we were hoping we could get.
Thank you, Your Honor.
Thank you. All right. Mr. Goldsmith.
May it please the court, good morning. My name is James Goldschmidt on behalf of Alliance RX. With me at council table is my partner, Stacy Alexton, who leads our representation of Walgreens in this and other matters. If I may, before addressing points of disagreement with the presentation you just heard, I'd like to offer a framework that will provide some structure to the discussion. It's along the lines of the questions that have already been asked. It'll take me about a minute to set up. The key concepts running through today's discussion of duty are first the source of the duty, whether it's pre-existing or assumed, very different things. And second, the scope or nature of the duty. Is it a duty to timely fill a prescription or a duty to fill the prescription, period? The source of the duty matters because whether there's a pre-existing duty is a legal question. whereas whether the duty was assumed requires evidence of assumption. That was already discussed. So what plaintiff needs to show to establish the duty differs based on whether we're talking about one or the other. The scope of the duty matters because on the legal side, we don't reach a duty of timeliness if there's no duty to fill the prescription at all. And on the assumption side, it defines what the plaintiff needs to show Alliance RX assumed. Did it assume a duty to fill the prescription, or did it more specifically assume a duty to do so within a particular time? Putting those two concepts together gives you 4 quadrants for your analysis. Pre-existing duty to fill, pre-existing duty to fill timely. Assumed duty to fill, assumed duty to fill timely. Keeping in mind which of those 4 quadrants we're in is really important to clarity of analysis, and if we lose sight of it, the analysis becomes very jumbled. In fact,
Was Walgreens' litigation strategy in proceeding on summary judgment to essentially assume Walgreens owed a duty from June 2nd until June 16th due to your corporate policies? Was that part of your litigation position?
our litigation position was a contingent argument that any duty we assumed, if any, was discharged or terminated by mid-June and not reassumed until July. That is not an admission that Walgreens assumed a duty at any time.
Did Walgreens ever, what needed to be said was, we've about had it. We keep trying to get this pre-existing approval, and we're not getting it, and we're tired of running around our office. We've got 10,000 other prescriptions, so you're on hold. We're just putting your file on ice. Go somewhere else, or come and hand us a pre-authorization, or we're not doing anything. Why didn't it have to tell the Scholls that? Because if it had told them that, things might have turned out differently.
So as a factual matter, the evidence shows Walgreens did leave a message saying that. There's a dispute in the record over whether Mrs. Scholl received it. As a legal matter, why didn't they have to do that? Goes back to the question of what is the legal duty here? Is there a legal duty to fill the prescription?
They lured him in a little bit, and realizing that's somewhat charged language, lured him in a little bit with, if you get us a pre-authorization, we'll fill your prescription. That's the only thing holding us back. And nice financial incentive to fill that prescription. These drugs cost a lot of money. And so if you're the consumer in that instance, you assume that they've told you, if you get the pre-authorization, we'll fill the prescription, and they got it, and they had no reason to think, so now they're not going to fill the prescription.
I respectfully disagree with the framing that's based on they told her if you get the pre-authorization, we'll fill the prescription. What they told her was, we can't fill the prescription without the pre-authorization. That's a very different thing. It's not a promise to do anything. And when asked for anything in the record showing Walgreens Alliance RX affirmatively saying, we'll do this, the concession was, it's not there. There's nothing in the record ever showing them doing that. Saying,
well, isn't there at least a reasonable inference, though, that if Walgreens is saying, look, the doctor's got to get the pre-authorization, why can't one infer from that, well, what that says is when the doctor gets it, we'll fill it?
that is not an appropriate leap, because
Well, why not? I mean, we're at summary judgment, right?
Yeah,
You're
yeah.
the moving party. Inferences for the non-moving party.
right. But
Why isn't it a reasonable inference?
because to assume a duty, we need something showing an affirmative representation by Alliance RX that it will do something, and keeping in mind the quadrants, not just fill the prescription, because it did fill the prescription. So ultimately, if it assumed a duty to fill the prescription based on this theory, it met that duty.
Right. Then let me just ask you this, and I'm not sure which quadrant I'm in, but didn't Dr. Hildebrand and the Scholls give Walgreens the pre-authorization number on June 16th?
Yes, sir.
Okay. And why didn't that trigger the duty?
Well,
Fill the prescription.
The question there is, trigger what duty?
The
Trigger a duty to fill the prescription?
Yeah, the duty to fill the prescription.
Because the only way we get there is either a pre-existing duty under Oklahoma law, which doesn't exist, or some assumption by Walgreens.
Well, well, okay.
And
So
simply
you're saying-
receiving-
You're saying that simply receiving the information is not enough.
It is not enough, because to assume a duty, there needs to be some response to that information,
Yeah,
such
but
as,
they didn't just receive the information. There'd been previous back and forth communications that, look, this is what we need if we're going to fill the prescription. And I'm kind of back to, we get to this point, and if we're drawing reasonable inferences from a course of conduct over that June 1 to June 16 period of time, why wouldn't the Dr. Hildebrand and the Scholls have a reasonable, foreseeable expectation that the prescription is going to get filled?
so the course of conduct that we're talking about is really only conversations, discussions back and forth between mostly Alliance RX and the medical provider, a couple with Mrs. Scholl, where the only thing Alliance RX said in any of those conversations was, we cannot proceed without this information. We cannot proceed without this information. That is not a representation that they will do anything. It is not an assumption of any obligation. It is saying no, no, no. In fact, at one point, the record shows Mrs. Scholl offered to pay. Alliance RX said, we won't let you do that. No again. At every point in this discussion.
Why isn't it a fair inference that you weren't going to do anything until you had what you needed to proceed? And once you had the authorization, you'd proceed. That seems to be an entirely fair inference for a customer to draw.
The first part is true. The first part is fair. We're not going to proceed without this. The second part is not a reasonable inference.
But what in your view would have made, what kind of evidence would have made that a reasonable inference? That second part.
If in response to any of those requests, Walgreens had said, as soon as we get that prior auth, we'll be right on it. We'll fill the prescription promptly. Or we'll fill it within a particular time. And again, keep in mind, Walgreens Alliance RX did fill the prescription. So what we're talking here ultimately is not about assumption of a duty to fill it, which they satisfied, but to do so timely. And so you would actually have to show a representation specific to how quickly we'll do that.
So
That's not there.
It seems that you agree that when you filled it in July 13th, that you actually filled the prescription, that you had a duty to do that then. What was the source of the duty then?
The assumption of that duty in response to the prior auth that came in July. Because the record does show that when the prior auth came in July, Alliance RX said, we will act on this and fill the prescription.
But
That's the piece that was missing back in June.
doesn't this all kind of defy reality? You're presenting this as though it's an open question, and sometimes Walgreens will fill one if they get the pre-existing, and sometimes they won't, and you take your chances if you roll with Walgreens. If you want some better representation, go to Walmart or somewhere. But my guess is that 99% of the time, when they say, get us a pre-authorization, they fill a prescription, unless there's a problem that develops. And there aren't any things like that in this record that I'm aware of. So you're cutting this awfully thin as far as what a consumer would understand.
So a couple of points in response to that. First of all, I think it's important to keep in mind, we're not talking about a retail pharmacy here where you go into the app on your phone and you see that a prescription has been received at Walgreens and they say, we'll have it for you by tomorrow. We're talking about a specialty pharmacy that's dealing primarily with medical providers and insurers. And so that framework on a level of practical reality doesn't quite translate here. That's important to keep in mind. The second point I would make in response is it's their claim that Alliance RX assumed a duty to fill this prescription within a particular time. That was the way they framed it today. That was the way it was framed in their appellate briefs. That was the way it was framed below. And to show that as an evidentiary matter, you need some representation from Alliance RX Not only that it would fill the prescription, which may be a fair inference from this course of conduct, but a specific representation as to how quickly that will happen.
What do you mean by a particular moment in time?
Any framing of timeliness.
Well, they're not
would have-
saying it had to be done in 4 days to the hour. They're saying it had to be done when your condition was met. We need pre-authorization.
So it's not actually clear at all what they mean by a duty of timeliness here because they never say. So they leave this court to fashion a standard of timeliness if that's the direction you want to go. Any representation regarding prompt filling of the prescription, quick turnaround, a particular number of days, any of that would check the box in our analysis, but it's not there.
I think what you're asking us to think about is that, that the plaintiffs presented a specific kind of duty, a duty to timely fill. And the evidence that we're looking for in terms of a course of conduct to support that duty has to be a course of conduct with respect to timeliness. Is that your position?
That's exactly right. Yes, Your Honor. And it's important to emphasize that timeliness piece, because if we're just talking about an assumption of a duty to fill the prescription, and you want to say that's a fair inference from what happened here, again, Alliance RX did that. It did fill the prescription. There's no dispute that that assumed duty, if it was assumed, was satisfied.
Counsel, didn't you also say that they did fill the prescription, but it was because they got prompted again on July 13 by Dr. Hildebrand and the Scholls, but they were prompted in a really, I don't know if it's any meaningful different way when after the course of about 2 weeks, they finally get the pre-authorization on June 16. And I'm wondering about this timeliness argument. I mean, Walgreens is at least on notice that this is a drug the doctor thinks is needed. I mean, why wouldn't they need it on a timely basis?
So I think it's important there to keep a focus on the provider's role in all of this. Walgreens Alliance RX only knows what it's told by the medical provider. And certainly, we know from the medical providers and from the family's side of the case that this was a time-sensitive situation, that it was a set of factors unique to this individual and her condition. The question is, how much of that did Alliance RX know, and how much of the responsibility was on the provider to emphasize the urgency of this situation to Alliance RX, because it was the provider's responsibility to get the prior authorization.
Are there certain drugs, maybe this one, where it's inherently a time-sensitive situation, just by virtue of what the drug is?
Yes, potentially. And again, if in response to that, Walgreens Alliance RX had said, based on that, we're giving you this assurance that we'll do this within a certain time, there would be a duty there.
Okay,
that just never happened.
I want to throw in one other question about this, rather than characterize it in terms of reasonable inferences. Is there anything in the Oklahoma law, case law, that sheds any light on this question of having to make this sort of affirmative representation that we're going to fill the prescription? I mean, we heard from counsel, they've got this Wofford case, but I wonder if you've got any cases that would help us.
Sure. So most of our focus has been on Oklahoma law and pre-existing duty.
Yeah, we're on assuming the duty.
Yes, and
whatever
we don't.
Quadrant 2 or 3, whatever that is.
We don't disagree with the basic premise of Oklahoma law that a duty can be assumed by words or conduct. We just don't have that here as a factual matter.
You have a case, though, that would tell us that this isn't the kind of situation to recognize an assumed duty?
Yes, if you'll give me just a moment, I am over my time, I apologize.
That's my fault, I'm asking you.
So I think the best case that I could point you to is the Hardog case, Harwood versus Ardog Group, on pages 40 and 41 of our response brief. That is a case that I think provides a good contrast to what happened here, where an Oklahoma appellate court found that there, an employer had assumed a duty to provide a safe sidewalk, even though the employer didn't own that sidewalk, because of specific representations that the employer had made to its employees about what it would do to keep that sidewalk safe. That's the kind of evidence that's missing here.
Thank you, counsel, and thanks to both of you. Appreciate the arguments this morning. The case will be submitted and counsel are excused.
Thank you.
The court will take a 10-minute recess.
Court is in recess for 10 minutes. Can I go ahead and address this?
They were all slightly taller than me.
The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Please be seated. Our next case is Jiang v. City of Tulsa, number 255097. Counsel?
Thank you, Your Honors. If it pleases the court, I'm Mark Smith, here on behalf of the appellant Jiang. Mr. Jiang has been a longtime servant of the City of Tulsa. He began his employment at the City of Tulsa in around 2010. He came to the city by way of China, where he earned a bachelor's and a master's degree in engineering. Then he made his way to the University of Missouri Loyola. In about 2006, I believe his resume says he got his PhD. He also obtained a professional engineering license. Mr. Jiang's resume also sets forth the experience he's had with that PhD. He's authored 14 journal articles. He's been asked to speak and present papers at over 28 conferences. He helped author a chapter in one of the best reference books for this area of engineering, and he's also received many awards. Mr. Jiang has basically dedicated his life to safe drinking water, and the people of Tulsa should be very thankful to have a man of this great talent. So in 2021, Mr. Jiang wanted to apply to move to a position of superintendent within one of the water plants. This move for Mr. Jiang was actually a lateral move. The purpose for him in moving to this position was because in the current engineering role he was in, there was not a path for him to move up the management ranks. He had to go somewhere else. The superintendent position, like I said, was a lateral move, not a demotion, not necessarily a promotion, but what came with it was the managerial responsibilities that would then allow him to start moving up his career and gain that experience later.
Well, the district court referred to it as a failure to promote claim. Is that wrong? The claim that you brought?
So technically, he wouldn't get a pay raise, but it does come with other benefits and other responsibilities that weren't available to him in his engineering role. So in the sense of gaining new responsibilities, in particular management responsibility, that would be, I guess, technically a promotion. Mr. Jiang himself did view it as a promotion because of those additional responsibilities he would take on. So the job description for this particular superintendent role, I think it's important to note that it had just been reviewed by the management team in April of 2021. And they did make some changes to it. It's not that they just reviewed it. They went through it and made some changes in anticipation of posting it to take applications for the open job. That job description expressly required a bachelor's degree in the particular fields of environmental engineering and technology. As part of the city's procedures, the job was posted for internal applicants. 3 applicants submitted their applications, obviously Mr. Jiang, Mr. Hutchcraft, and Mr. Curry. It is then part of city policy that those candidates have to go through a process called certification. And that's basically where the HR department makes sure they check all the boxes in the job description requirement. Those 3 candidates were certified by HR. They were administered tests that were not scored, that were meant to test their technical aptitude. They then engaged in a round of interviews with 3 panelists. The 3 panelists included on the panel was actually the decision maker, Ms. Hunter, who would be making the ultimate decision. The panel was giving a list of questions where they could write scores and sort of rank the 3 candidates. The scoring was not outcome determinative, as we've said in these depositions. It's not whoever gets the highest score automatically gets the job. And there was no process for, well, do we add them all up? Do we take your average score? Do we throw out the lowest score? It was all there just for Ms. Hunter's ultimate consideration. At the end of that first round of interviews, Ms. Hunter obviously selected Mr. Hutchcraft, who she believed to be the top candidate. She described him as even across the board. Mr. Jiang filed a grievance with the HR department, citing both failure to follow policy in certifying these candidates and claiming race discrimination. HR denied that. He was then exercised his right to appeal that to the Civil Service Commission. The Civil Service Commission did agree with Mr. Jiang that the city should not have certified those two other candidates, leaving Mr. Jiang as the only certifiable candidate that applied. In response to that, HR department went and changed the job description.
There's a valid reason to do that, though, right? Which is, otherwise we only have one applicant.
Well, the city policy allows them to open the application process to outside applicants. They never looked at that route. So there were other tools besides, we have to just change this job description.
What does outside applicants mean?
Well, people who aren't currently employed with the city of Tulsa.
So
that's
this one was within the city of Tulsa.
All three of these candidates were. It was only advertised internally, both rounds. And that's something that was available to them under that policy, was to open it to outside applicants, which, who knows how many applicants they would have gotten. And so, no, I don't think it was the only way to get more than just Mr. Jiang to be an applicant was to change the job description. They could have looked elsewhere. And they could have put some effort into recruiting as well.
Did the amended job description lower the requirements?
It lowered the educational requirements, yes, Your Honor. It went from requiring the bachelor's degree in those specific fields of engineering and environmental sciences to requiring basically 60 hours.
Well, it seems that the city is arguing that didn't lower the requirements, but just altered the requirements to comply with the Civil Service Commission's decision. How should we be thinking about that?
I think that's a twist on what the Civil Service Commission found. The Civil Service Commission found that these guys could not be certified at all because they didn't have the degree requirements. It's important to note in the policy, and the city argues that they amended that policy, but they didn't. The policy says if the job description requires specific degrees, then you cannot substitute experience for those specific degree requirements. And that's exactly what this job description had. So I've seen it in multiple places, the city laws, hey, we changed our policy to match past practice. That rule still exists in the new policy.
Well, counsel, as I understand it, it isn't the city's contesting the content of the policy. I think what they're trying to say, if I understand it right, is that there was a long-standing practice, notwithstanding the policy, to substitute experience for education. Did Mr. Jiang present any evidence in district court to dispute that the city was following a long-time policy in the way it substituted experience for education?
Well, I think that's one of the issues with the city's.
No, was there any evidence that your client presented at summary judgment to create a genuine issue of material fact on whether that was longstanding practice?
I think the problem is that's, well, so I'm not trying to avoid it, but I have to address the affidavit to get to the bottom of your question, Your Honor. And that being, Ms. Felix Warren's affidavit is the only evidence in the record. And it's her just bald statement that I've been doing this for 23 years and I've always violated policy. But there's nothing else that they presented besides just her bald statement of that.
Well, it's an affidavit that is unrebutted.
It's not.
Where's the counter evidence?
Well, the counter of it is to look at what actually happened in Mr. Jiang's case and look at the actual policies.
Isn't the counter evidence that, no, this isn't the way you've done things for the last 25 years? But there isn't anything, is there?
I think there's because there's an absence of any evidence that they actually did that besides the affidavit. The evidence in this case is that they did it this one time and it favored two white younger candidates over
That
Mr.
isn't what
Jiang.
the affidavit's about. The affidavit said, look, we've always done it this way. And I'm not saying that's a great rationale, but it's the rationale. And the question I'm asking you is whether that's a fact, even though it's just one affidavit, but at least it's something. I mean, you know, affidavits are used to support summary judgment. And was there anything to rebut the past practice?
Well, I think the CSC's determination, telling them you can't do this, I mean, it belies logic that all of a sudden the Civil Service Commission saying you're not following policy, but you've been following policy for 23 years. You told me nobody has ever challenged that in 23 years except Mr.
I don't see
Jiang?
anything, I've got it on screen. Where did the Civil Service Commission say anything other than this didn't follow policy? They didn't say anything about past practice.
Well, that's what the city is trying to say
I know,
as
but you're
well,
saying
but it
that
doesn't
the-
say it either. I mean, the problem is the affidavit is not supported by anything. It's just a bald statement.
It is?
Yes, it's her just saying for 23 years I violated this policy, but
Is that what?
it provides nothing else to
is
back that
Are you
up.
quoting that? Is that a quote from the affidavit? I violated policy for 25 years? And even if it is, isn't that evidence of a common practice?
Just straightly answer your question, Your Honor. I don't believe that's a quotation. I do want to pull out the affidavit. Yes. The city's practice for at least 25 years prior to August 12, 2021 was that an employee could substitute work experience for years of education at a rate of 1 year of experience for 1 year of education, so long as the employee had half of the stated education requirement.
Remind me who this is again.
It's Ms. Felix Warren, who is the personnel director, the head of HR, and she has a role with the CSC process as well.
Isn't that someone who would be in a position to know that that is a correct statement of fact?
She would certainly know, yes, Your Honor.
All right, I don't want to belabor the point, but.
Well,
go ahead.
as part of that, I mean, if that is the practice, I would challenge that, you know, what part of the practice helped Mr. Jiang at all? Because everything they did made it harder for Mr. Jiang, even though originally he was the only candidate that should have been certified at all. Then you go strip away the educational requirements, and then you put him in these interview panels where, in fact, Mr. Vaughn rated him the highest candidate in those interview panels. And so when you look at the disequal treatment on the facts of this case, regardless of how long they say they've been violating this policy, then it shows that Mr. Jiang did not get a fair shake here. And it's important to note that he's applied for 9 different promotions and moves, trying to get himself into a different position. And I think if you look at some of the testimony from Mr. Eric Lee, where I asked him about this, you know, how is it that Mr. Jiang can break out of this engineering role and actually get himself into a management position? They had evidence of white males and a white female who had done this before in the past. Like Mr. Jiang, they were stuck in an engineering role, they were able to move laterally. And the only suggestion that came about was from Ms. Hunter saying he should actually take a demotion. And the problem with that is, obviously working for the city can come with great benefits. One of those being that your retirement is based on how much you're earning. So for him to take that demotion, it would be a risk that maybe he never gets back up.
It was the same pay, wasn't it?
For this superintendent role. Ms. Hunter's suggestion was he actually go to the supervisory role, which would be an EX40, not an EX44.
Okay.
And that's the other thing, is that supervisory role maintains a job description that requires a specific college degree, to where the superintendent who they report to is no longer required to have as much education. And that's part of where's the business justification for all these changes? And that's what I challenged all the witnesses, is why do this? Why change this job description? And most of them said the EX44 level, it is important to have a college degree because you're managing people and you need the technical know-how. And so I think.
But those are 2 separate things, right? And that was at least the asserted answer for why he did not get this job. He had technical A+ and management C-.
But that is Ms. Hunter's subjective opinion of his management experience. I
But
think
the,
if you look
the
at
other
Mr. Lee's
evaluators
deposition.
did not rate him highly in the management and the supervision. And as you say, the reason that he was interested in this is so he could get some experience. In other words, he didn't have much.
That is true. But I think Mr. Vaughn's deposition testimony and Mr. Lee's deposition testimony, I go into great lengths with how much management experience Mr. Jiang has. And, you know, Mr. Lee talks in particular about Mr. Jiang's leadership of the top ops team, which is a basically Jeopardy-style competition team. And he created the program in Tulsa, and 2 years later, they were national champions. And how proud he was that he had built that program for them. You know, he had to manage all sorts of coworkers and outside contractors as part of these multi-million-dollar projects that he oversaw, capital improvement projects. And if you look at the way Mr. Lee and Mr. Vaughn talk about that experience that he has and how great that was, and contrast it with Ms. Hunter's explanations of, oh, he's taking all the credit for team projects, and I'm sorry, I'm out of time.
You can finish up your thought.
Yeah, so if you, the juxtaposition of Mr. Lee and Mr. Vaughn's discussion of his management and leadership experience versus how Ms. Hunter just discounts everything and says he's taking credit for what were team projects, he's exaggerating. You can tell that she held specific bias against Mr. Jiang.
Okay, can I ask one question? Could you clarify something for me on your retaliation claim?
Yes, Your Honor.
So what adverse actions form the basis for your retaliation claim?
So the second denial of the promotion is the base adverse action, okay? And we also believe that HR rewriting this job description to allow the second round of interviews, we believe that that was a retaliatory action as well. HR got
Can I
rebuked.
just do a follow-up? Because
Yes.
the city contends that you didn't argue that in district court, that the second non-selection was retaliatory. I take it you disagree with that.
I do disagree with that, Your Honor. I think we presented all these issues. And again, that gets to some of our arguments about the court's myopic focus on discrete acts and discrete actions as opposed to taking a holistic view as we should on summary judgment.
Thank you, counsel.
Thank you, Your Honor.
Hayes Martin for the City of Tulsa. May it please the court. This is a case about disappointment, not discrimination. This is not a case about whether the City of Tulsa made the correct decision in choosing a candidate other than Mr. Jiang. Instead, this is a case about whether Mr. Hua Jiang, a disappointed job applicant, has produced evidence from which a reasonable jury could infer intentional discrimination or retaliation. The district court correctly ruled that he did not. This court should affirm for 3 reasons. First, the district court correctly applied the Rule 56 summary judgment standard within the McDonnell-Douglas framework. There is no genuine dispute of material fact in this case, and the district court did not improperly weigh credibility or evidence. Appellant's contentions are based on conjecture, speculation, and often statements not found in the record at all. When evaluating the admissible evidence that could go to a reasonable jury, no reasonable jury could find for appellant. Second, regarding the retaliation claim, the district court correctly held that Mr. Jiang did not establish a prima facie case for retaliation. Mr. Jiang certainly had protected opposition. He complained that he had been discriminated against. However, he also has to show an adverse employment action and show a causal connection between those.
So, but didn't the district court treat Mr. Jiang's non-selection as the basis for his retaliation claim? Do you agree with that?
So for the most part, yes. The issue would be that Mr. Jiang did not craft a clear retaliation claim. He cited to tens of pages of deposition testimony and a 3-page document entitled Retaliation and Intimidation Records, and simply stated retaliation happened. Did not clearly articulate that he was claiming the second change was that the second non-selection was a retaliatory act until appeal. However, even so, cannot show causation. The City of Tulsa had the same justification, the same operational needs during the first selection that it had during the second. There is no way that Mr. Jiang can demonstrate some retaliatory animus that somehow manifested. The City of Tulsa was consistent in its justification, in its process, and its decision.
I'm a little confused. So
Yes.
are you saying that the October 2021 non-selection should be viewed as an adverse action, except the city still prevails on the causation element?
Had Mr. Jiang raised it at the district court,
Okay, so you
That could- yeah.
maintain your position that it wasn't properly advanced in the district
yes,
court?
a
And so-
non-selection could be.
And so my question is, it seems that the district court did pass on it, or at least understood it that way, and my question to you is how we should be thinking about that.
I think that's the district court viewing it in the light most favorable to appellant's claims, is that the change in job description is not an adverse employment action. None of the other things that he lists as an adverse employment action. The only thing that possibly could be would be the second non-selection, but there's no causal connection, and similarly would still fail on pretext. And then regarding pretext, there is no evidence of pretext sufficient to discredit the city's legitimate, non-discriminatory justifications for its actions.
Let me ask you a question about
Yes, sir.
pretext. So the Civil Service Commission said that under city policy, Mr. Curry and Mr. Hutchcraft should not have been considered for the promotion in the first instance.
Yes, the first, there were two civil service appeals. In the first civil service appeal, after the first non-selection, first certification process, the Civil Service Commission stated that they determined that the city did not follow the policy as in the city's position, as the Civil Service Commission understood it.
Okay, that's the first half.
Yes.
Of my question. So then, HR changed the job description so that they could be considered.
HR changed the job description to match what the past practice had been. And,
Well, it just so happened that Mr. Curry and Mr. Hutchcraft are back on the list.
well, so the city had applied this policy and procedure in that manner, as Ms. Felix Warren stated, but also as other witnesses testify. Ms. Hunter stated this is how she understood the process. There actually is an instance of another superintendent that does not have one of those qualifying degrees. Furthermore, Mr. Hutchcraft was certified for his Sure.
I'm still trying to get to my pretext question.
Yes, sorry.
And it just seems like what happened here is that in this process, there was, at every step of the way, it seemed like they were trying to put Mr. Hutchcraft in a position to get selected. And when it didn't work the first time, because of the degree requirements, Civil Service Commission comes back and says, that just violates our policy. HR turns around and says, oh, we're going to rewrite the job description. It just seems like there's some manipulation of the process there to get to the same result. Why isn't that pertinent to pretext? Why doesn't that raise some questions about the way Mr. Jiang was being treated?
Sure. What we're looking at for pretext is whether or not we have a disturbing procedural irregularity that uniquely disadvantages and directly disadvantages Mr. Jiang based on a protected trait. Here, as I cited, there's a unpublished or 10th Circuit opinion, Hamilton versus Oklahoma City University, that dealt with a similar process where the selected candidate did not meet the job requirements for the job. They required a PhD. They selected someone that had not completed their dissertation. They did not have a PhD. And the court, 10th Circuit in that case, stated that that alone, while it might have disadvantaged him based on his educational status, it was in no way related to a protected trait. We're looking at a similar thing here. Any change does not affect Mr. Jiang based on a protected trait, whether it's his age, national origin, or his race. He can only allege that he's disadvantaged because he wanted it to be a degree contest, and that's not what happened. And the change by the city is a compliance measure that the city had been managing its HR in a certain way for years. This appeal we have a disinterested commission based under our charter that makes this determination, the Civil Service Commission, and the city says, no, that's the way we liked doing things. That's how we've done it. That's how we want to keep doing it. We're going to make these changes to continue doing it. And that's what they did. There's nothing that says that as soon as Mr. Jiang makes a complaint that it freezes the process in time and the city can't change a job description. There are 10th Circuit cases that show you can change a job description to lower the requirements. That's not a disturbing procedural irregularity on its own. And similarly, the 10th Circuit has held that certification of candidates that don't meet the educational requirements isn't enough on its own. There's no link here that can show that change in any way is connected to a protected trait, and that is where this is fatal for Mr. Jiang on procedural irregularity.
Okay, just press it a little bit more.
Sure.
If they hadn't changed the job description, at that point, wouldn't he be the only candidate?
If they didn't change the job description, didn't change any policies, he might be the only candidate, and that does not mandate that he would be selected.
No, I understand that, but, and I understand your argument, you're reading at the evidence, but would it be reasonable for a jury to say, what's really going on here is that they were going to do everything they could not to select Mr. Jiang. That's what's going on, and that's pretext.
I think the issue here is that Mr. Jiang never was going to fit the operational needs with his his education doesn't get him there. You know, Judge Phillips was correct. It's absolutely an A+ in education, the highest education of anyone that applied, a huge amount of academic knowledge, but very limited actual operational experience or management experience. All of Mr. Jiang's arguments about qualifications deal solely with his strength. He never contends with his weakness, and he never contends with the other applicants' strengths. You know, this was a situation where there were 3 applicants, all strong in different areas. Mr. Hutchcraft was the, I struggle with it, it's almost like a Goldilocks. You know, one has, or Mr. Curry has a ton of management experience, but doesn't have the technical experience you need. Mr. Jiang has a ton of academic knowledge. No one contests that, and the city values that in his position as an engineer. But he didn't have the operational or management experience he needed. Mr. Hutchcraft, those met in the middle where he had that operational knowledge as an operations supervisor, and then had that management experience from that position and from his time in the military.
Let me shift gears for just a
Yes.
second. I want to make sure I'm understanding your position on the retaliation claim. I know you've already talked about it a little bit, but do you agree that Mr. Jiang's non-selection the second time, however it was argued, but the non-selection the second time, that would be an adverse employment action?
Yes, the non-selection would be an adverse employment action, yes. Now, regarding the other claims, Mr. Jiang also argues that the process was wholly subjective. I think Mr. Jiang falls into a fairly common trap of relying very heavily on Garrett versus Hewlett-Packard. This case is entirely an opposite to Garrett, where what we're looking at is a very transparent process, more like Hines versus Sprint Management or Conroy versus Vilsack, where everyone can see what the thought process was, how everyone was scored. It's entirely transparent. And you're necessarily going to have subjective determinations in any process, as this court has held. I'd also like to address regarding business justification. First, not raised at the district court. There was no contention by regarding the second prong. Mr. Jiang made no argument at the district court regarding the city's legitimate business justification. On appeal, argues that the district court crafted one for the city. I look at it as it's worded slightly differently than the way the city words it. Either way, still supported by the record. What's disturbing to me is that most of the evidence related to other managers stating that they don't see the business justification. One, I don't really see that strongly in the record, and where it does show up, it's other managers in different chains of command that are not responsible for this position. Particularly, Eric Lee was not a manager at the time, was not involved in that decision, so any exclusion of him makes sense. Why would he be excluded in that decision? Ms. Hunter stated in her deposition that she didn't recall if she was consulted, but was sure she was. Appellant states, both at the district court and here, that she said she wasn't consulted, which is not supported by the record. And the record also includes the job description request for action. It includes the email that loops in Stephanie Hunter on that decision. And also, very glaringly with Joe Brown, appellant states that she said that she felt HR had discriminated against Mr. Jiang. I addressed this at the district court. I addressed it in response here. At no point has that been retracted by appellant. Didn't address it in his reply when Ms. Brown very specifically said, no, I don't feel he was discriminated against by HR. She certainly didn't like the process, but her liking that process is far afield from stating that she thought it was discriminatory, and she very much so stated she did not. All of this is to say that the entire basis for appellant's claims are, it's speculation from people that don't have personal knowledge, it's conjecture from himself, or it's not supported by the record. The district court correctly viewed the record evidence. There are things that appellant claims were disregarded because they aren't supported by the record. The district court—
Can I ask you a question about
Yes,
how the
Your Honor.
district court viewed the record according to what our law requires for pretext?
Yes.
So it seems to me that the district court may have been thinking that about pretext plus, which is not the law, right? And the district court said in discussing Mr. Jiang's discrimination claims and then the city's amendment to the job description said, plaintiff has not identified any comments by coworkers or other incidents suggesting he was subjected to mistreatment because of his race and age. But he didn't have to do that, did he, to satisfy the standard? It seems that if the court is evaluating the record evidence under a pretext plus standard that isn't the law, wouldn't that be reversible error?
So I would disagree that that's what the court was doing there. What the court was doing is, looking at first, is there any direct evidence of discrimination? If there is, we don't apply McDonnell-Douglas. So the court, when stating plaintiff has not identified any of these things, is stating that plaintiff has not identified direct discrimination, so we have to move to McDonnell-Douglas. That's what this circuit holds. That's what the court did. So I know that I don't think there's any rational argument that that's really what happened
Do you
here.
think the best reading of what I just read to you is this goes to direct evidence of the absence of direct evidence of discrimination?
I see I've run out of time. Can I go ahead and answer?
Please.
Yes. Yes, that is exactly how I read it, is that is the start of the section on, I believe pretext, but it's during the McDonnell-Douglas discussion. That's the court identifying how we get to this analysis anyways. Thank you.
Thank you, counsel. Okay, I think you both went over a little bit, so we'll take the case as submitted, and counsel are excused. I'd like to thank both of you for your arguments. Thank you, Your Honor. Right, our final case of the morning is Stepp versus Lockhart et al., number 257038. Counsel, you may proceed.
Good morning, may it please the court. My name is Adam Breipol, and I'm present on behalf of all of the appellants other than Kevin McClain, and I do intend to reserve 5 minutes or as close as I can for counsel for McClain. So there are a lot of parties and claims in this appeal. I assume we're probably not going to have time to address each and every one in a lot of detail. So I'd like to focus on some overriding issues that I believe govern this court's analysis of all claims. First, I think it bears emphasis how complex and unusual compared to the average school civil rights case the fact pattern is that's alleged in this case. It arises out of a situation where Tallahassee Public Schools, for a certain period of time, had a policy in place in which classroom assignments were based on sex, such that there was a boys' classroom and a girls' classroom. And some of the issues on this appeal relate to the facial lawfulness or unlawfulness of that policy. In the boys' classroom, there's also allegations that Appellant McClain engaged in inappropriate remarks and yelling and things like that directed towards the minor plaintiff JS. And so some of the claims deal with who is, if anyone, is liable for that conduct. His parents filed a Title IX complaint regarding those issues, and there are issues in this appeal regarding how that appeal was processed. There are issues related to a change in the way that JS was provided with an education after the complaint was initiated and while it was being processed. And then finally, there are allegations of post hoc retaliation against the plaintiffs, this JS and the Stepp family. The important thing is that not every individual defendant in this case is alleged to have been involved in the same way or to the same degree every step along the way. And what that means is that it's particularly important that a court evaluating the issue of qualified immunity as to these individuals focus in on the specific conduct and knowledge and role of each individual and not to paint them with the same brush regardless of what they're actually alleged to have done. Ever since Twombly and Iqbal were handed down, the appellate courts have made it very clear that it's particularly important that a plaintiff allege specifically who is alleged to have done what to whom in order to serve two purposes, both to give the defendant a fair knowledge of both the factual basis and legal theory for the claim that's asserted against them, and to allow the courts to evaluate whether a plausible claim has actually been alleged.
Counsel, I take your point about personal participation. I'm not sure we're going to have the time to kind of work through each and every claim with each and every defendant. I mean, that's something we're going to have to study.
Exactly.
In terms of the complaint and the arguments you've made. I don't want to throw you too far off course on your basic points, but I know we're going to have a number of questions about the specific claims. Are you ready to take those at this point?
Certainly, whenever Your Honor would like to jump in on that.
All right, I will. I'd like to start with the, like as you said, there are a lot of claims, and you're representing everyone but Mr. McClain, correct?
Correct.
All right. So, tell me on the procedural due process claim, why doesn't the complaint adequately allege a deprivation of a property interest in public education based on the segregated classroom policy?
So it's established that there is a property interest in education on behalf of a student, but the case law doesn't go as far as saying that every aspect of the way that an education is provided falls within the protected property interest. For example, we cited the Zamora case where a student was taken as a result of discipline, was required to go from the normal high school to an alternative high school that didn't offer sports and allegedly wasn't, as preferable of a placement for that student. But this court explained that he was still being provided an education, so the specific setting that the education was being provided in didn't raise to the level of a constitutional deprivation. So in this case, what's alleged is that JS, after he his parents made this complaint regarding McClain, that he was taken out of the classroom and put on a remote, out-of-school educational setting. So that is different than an out-of-school suspension where, as a student, you're out of school, you're not being provided with an education at all.
But just to make sure that I understand the facts that are relevant to this argument, the modified plan went on for 6 weeks and JS was given an hour of instruction per day. Is that correct?
There's actually two different changes that were made based on the allegations of the complaint, of course, since we're at the motion to dismiss stage. So initially, when the complaint was made, I believe they say the same day that they made the complaint, JS was sent home and put on a remote education. And they do say he was sent home with work to complete and continue to receive grades. The amount of time that went on is not specified, but at a certain point, there was a discussion about how he would be educated going forward, and they allege they didn't want him to go back into Mr. McClain's class, and they didn't want him to continue on this remote plan. And so instead, what they did was kind of a hybrid schedule where he spent he was at school receiving one-on-one instruction.
So it's your position, if I understand it, that a suspension is what would trigger the deprivation, not the facts here?
Yes, if it's, I would look at it as there's levels. If it is an out-of-school suspension, you are out of school, not receiving an education for more than 10 days. Under Goss, you have due process and a full hearing right. If it's a short-term out-of-school suspension, but due process is still triggered, but a lower level of process is required. So that could just be notice of the charges, right to respond to them. Then the next level would be if there is, for example, taking a student and putting them in virtual rather than in-person instruction. I don't believe that the case law establishes that it's clearly established that that implicates a student's property right. Think about it, about 6 years ago, in 2020, a lot of schools were putting people on remote education, and schools didn't have to provide a due process hearing for each student that their parents may have not approved of that.
In the second phase, he got 1 hour of language arts, and otherwise it sounds like he was just kind of parked in the library is the way I pictured it. You're saying one-on-one instruction? Was he instructed all day long in each of the subjects?
This is a tough one because I'm trying to stay within the allegations of the complaint. But I think the important thing is that they do allege that there was some instruction provided during the day in person, and that if you look at the allegations regarding this time frame, they're pretty clear that you can't continue to receive work to do if you're not receiving an education. You can't continue to receive grades if you're not being provided with an education.
Right. But as far as drawing lines and an alternative high school, that's one thing. You're going to classes, you have math, you have social studies, whatever else. But here, the way that I read it, it's just he's kind of cast off. Go to the girls' class or else.
Well, I think it's important to keep in mind that the question here isn't whether it was an action that would implicate due process to put him on that schedule. It's whether it was clearly established, because that's what would be necessary for it to be a basis to deny qualified immunity to the individuals that were involved in that.
Did the district court reach a ruling on that?
That is kind of the overriding issue that I wanted to get to, is if you look at the district court's order, the issue of clearly established law really is not specifically addressed on most of the claims. The two prongs of the qualified immunity analysis need to be, they're related. They don't necessarily have to be addressed in section 3A, 3B, but they both have to be addressed. And that wasn't done, and we believe it's error. And I'm happy to ask, to field more questions if you have them, but I'd like to reserve the rest of my time for McClain's counsel.
I think we're just getting started, counsel. Let me ask you about the equal protection claim. So the school district, the school, decide to segregate classes based on sex, why isn't that at least the beginning of an equal protection claim? You've got a protected category. You're distinguishing on the basis of sex. Doesn't the school district need to satisfy intermediate scrutiny to justify having done that?
I would say that with the procedural posture we're in, the plaintiffs had the burden to prove both, or to show that it's clearly established that that this policy both is unlawful and that the proffered justification fails intermediate scrutiny. There's limited information in the record that's before us right here about the reasons for the policy, but it had to do with being able to address issues related to proper conduct, and then also to have frank conversations that couldn't take place in a school setting. So I would submit that it would be the plaintiff's burden to show that it's clearly established.
You're jumping to prong 2 again, correct?
Exactly.
All right. We could spend a lot of time on each one of these, but I'm going to move on.
Can I ask a
Yeah,
follow-up
go
question
ahead.
on the equal protection claim? Can you help me understand, in your opening brief, in discussing the equal protection claim, you argue that plaintiffs failed to allege conduct that would constitute deliberate indifference, and I'm not sure I understand how that fits if we're looking at this as a sex separation policy under intermediate scrutiny.
Well, I think has been some confusion if you look at the record about what the theory behind, we're talking about count 5, as I read it, as to what the theory is, and there's been some discussion where it is more of a facial challenge to the policy, and there's been some other discussions where it's more of a theory of, by putting in place this policy, it said about the chain of events in motion that led to JS being sexually harassed allegedly by McClain. So there's 2 different theories that are discussed.
Okay, I'm going to jump to count 7, which is the conspiracy claim. If I'm reading the district court opinion correctly, and correct me if I'm wrong, but it seemed like the district court didn't rely on qualified immunity to dismiss it. It said, or didn't rely on qualified immunity to deny your motion. Why do we have interlocutory jurisdiction to address count 7 if it's not a qualified immunity ruling?
Well, I think it would be a little bit different than the other claims because my clients raised the qualified immunity defense as to all the Section 1983 claims. And so I think that puts it on the incumbent on the plaintiffs to overcome the presumption of qualified immunity that attaches once it's raised.
Well,
and then
if
also
the district court didn't rule on qualified immunity grounds, then why are we even talking about it now?
I think our position would be that the district court needed to address that in order to keep them in the case going forward because they're presumed.
That's a different argument. If you're arguing that they failed to address it, wouldn't we just send it back?
That may be, if that is the way that the court chooses to view it, then that could be a way that that could be disposed of. But I think our position would be that once it's raised, with regard to several of the claims, qualified immunity is kind of discussed up at the start of the Section 1983 claims, and then it's kind of only implicitly discussed.
All right. I mean, let me just preface my next question with, I'm asking you a few of these things to see if we can get our arms around the scope of what we're dealing with on this appeal. So the next one is more just a matter of asking you whether you're challenging the denial of the motion to dismiss count 9, because I didn't see discussion of that in your brief. But again, I might have missed something. So is it there?
Of course, I'm over time. I'll answer your question. There's 2 different retaliation claims. One of them is count 6 and one of them is count 9, and I think we addressed them in the same proposition.
So what you're saying is that you covered both?
Yeah, it's the same analysis, it's just against different defendants.
Okay, all right. Well, I'm going to hold off for now unless, we may want to hear from you again, even though you're over time now, so don't go anywhere.
All right, thank you, Your Honor.
Oh, I'm sorry, we have Mr. Callaway. Maybe we ought to hear from you. He wanted to give you 5 minutes, and I had a feeling this was going to happen. Let's give him 5 minutes.
Thank you, and may it please the court, my name is Jason Callaway, here on behalf of Appellant Kevin McClain, who is asking this court to reverse the lower court's decision to deny qualified immunity on appellee's substantive due process and equal protection claims. And I'll turn to the substantive due process claim first because it's a little bit more straightforward. On substantive due process, the analysis is always, does this shock the judicial conscience? This is an incredibly high standard. It has to be something more than negligent injury. It has to be something more than reckless injury, misuse of government power. It has to be something higher than that. And I think this court back in 1996 essentially decided this question for us. In the Abeta decision, Abeta versus Chalma Valley Independent School District number 19, the court said it is theoretically possible for verbal abuse alone to constitute a deprivation of a student's substantive due process rights. But first, it would need to be equivalent to forced stomach pumping. So whatever it would need to be, it would have to be the equivalent of that. And second, more importantly,
how would you ever get the equivalent of that?
I don't know, but this court allowed it as a possibility. Second, and more importantly, the facts of that case did not meet that standard. And I say that's important because we view the facts of this case, as alleged in the Second Amended complaint, as at minimum no worse than what was alleged in Abeta.
So you're arguing now the clearly established prong?
We're arguing both, that under Abeta there was no constitutional violation at all, but if this court were to decide there was a constitutional violation, that Abeta was the clearly established law, and that Mr. McClain would not have known at the time on knowing what Abeta said, that this court would subsequently decide differently now.
Well, what if there is, hypothetically, a determination that the conduct shocked the conscience? How does that, I mean, we're used to dealing with the clearly established law in a lot of other contexts, but this one, I'm curious how courts are supposed to evaluate conscience-shocking conduct under clearly established law, because one of the ways to get to clearly established law is when the conduct is obviously a constitutional violation. So if something shocks the conscience, why wouldn't it be obvious? How do the two prongs interact in a substantive due process shock the conscience context?
I think in this particular context, the educational context, and specifically verbal abuse alone, essentially what courts have said is that it never shocks the conscience.
Well, that wasn't my question. I'm asking you to assume it does.
Okay.
Assume prong one. A reasonable jury presented with the facts alleged in the complaint would find that Mr. McClain's conduct was egregious, outrageous, and conscience shocking. All right, so again, hypothetically, but let's assume that, because what I want to know is, if you've got that in hand, how can you not have prong two?
Essentially because courts have so frequently said that this is not conscience shocking. So if there were to be facts at some point in the future that met what this court said in Abeta, that there is verbal assault equivalent to forced stomach pumping, if you got those facts, whatever they may be, you could say, this here is enough.
So if we decide prong one in favor of the plaintiffs, but really decide it, and you still win on clearly established, then the next case may solve Judge Matheson's question. Is that your position?
Yes, Your Honor.
But if you lose on the first prong here, back to Judge Matheson's question and the follow-up, sometimes you don't have to have a case directly on point from the Supreme Court or the 10th Circuit. The conduct is just so bad that we say every person except incompetence or those willfully obeying or violating law would know. And so, and I understand Abate says what it says and the allegations there are what they are. I don't think they're as bad as they are here. So if they're worse here and we said, that's conscience shocking, good enough, couldn't we just say on prong 2, it's clearly established because anybody would know that this violates the Constitution?
And I think that goes back, and I'm sorry I'm out of time, I'd like to finish answering if I can.
Please do.
I think that goes to the fact that no one has found conscience-shocking behavior in verbal abuse alone. If no one has ever found it, then it seems like by definition, if one court finally does, you would have to say, well, it wasn't clearly established before that meets the standard because nothing ever has before now.
Unless it's egregious enough.
If it's egregious enough to be equivalent to forced stomach pumping, then it would, under Abate, already be clearly established because that's what this court has said would be what it takes. Thank you.
Thank you, counsel. All right, we'll move to Appellee, Mr. Johnson.
May it please the court and good morning, your honors. My name is Blake Johnson. With me is my co-counsel, Kelsey Schrimmer, and we represent the plaintiff appellees, the Stepp family. This court should affirm the decision below because in 2022, no reasonable state actor would doubt that the Constitution prohibits the segregation of public school classrooms by sex, a teacher's aggressive sexual harassment and gender bullying of an 11-year-old boy, or a campaign of retaliation against parents who filed a Title IX complaint. In each of these questions, the answer was and is clearly established. I think as an organizational...
You're asking us to make assumptions about the legal analysis on the face of a district court order that seemed in part, or tell me if I should be thinking about it differently, but at least to me seemed in part to conflate the first and second prongs of qualified immunity. And why isn't that reversible error?
Well, I do see it a bit differently, Your Honor. I think the correct answer to your question to opposing counsel was that the district court did in fact decide that with respect to the procedural due process challenge, there was a clearly established law on the question. The district court's order in the McClain appeal at page 12, and in the other appellant's appeal at the order at pages, I believe, 22 to 23, both clearly cite this court's decision in Couture as well as the Supreme Court's decision in Goss as the clearly established law on the procedural due process claim. And I think that's true in general of the district court's order. Now, I'll suggest, candidly, that there's fairly threadbare and anemic recital of the qualified immunity assertion in defendant's own motion to dismiss at the district court stage. And so, the district court's analysis, which to the extent that it conflates those questions, probably generates from the fact that in many instances, the defendants, the appellants in this instance, the appellant's own defense
But
tends
you have
to.
the burden. I mean, they raise it, and then you have the burden. So
That's right.
So I take it, in your view, you presented a robust prong 2 analysis on all the claims. Is that your position?
I couldn't have put it better myself, Judge.
Did you do that in district court?
We did so,
Okay,
absolutely.
And if the district court really didn't pick up on that, what should we do with that? Do we have to do work that the district court didn't do, or should it go back to the district court? What should happen?
And I guess I'm slightly confounded by the proposition that the district court, in any sort of reversible way, conflated these two prongs. There are arguments advanced.
It was anemic. I mean, we're at least at the anemic point.
Oh, and I'm sorry if I was misunderstood. I was referring to the assertion of qualified immunity in the appellant's motions to dismiss.
Well, I don't know that they have to do a lot to put the burden on you and then on the district court to address the issues. So So you're saying the district court, well, it certainly wasn't as robust as your arguments. Would you at least agree with that?
I would defer to the appellate judge's assessment of the district court's.
Well, let's say we're not, grading homework, we're not
Yeah.
saying it should have been better. I mean, in the district court's order, if the court does not mention the clearly established prong for certain claims, do you agree that that's reversible? Reversible may be remandable for the district court to complete the thought. But if the court, does not mention an analysis at all of a second prong, what are we supposed to do with that on appeal?
Well, I think it would probably depend on the particular constitutional challenge that the plaintiffs advance. I guess probably the most persuasive way that I can answer Her Honor's question is to assert simply that with respect to each of the plaintiff's claims, and I'd love to address those in their particularity, with respect to each of the plaintiff's claims, we believe that there is clearly established law that would put a reasonable state actor in the appellant's position on notice of the impermissibility of the conduct that we allege.
Just to ask you, maybe this goes more to the procedural due process claim than the others, but as I read the complaint, it alleges that the school district was responsible for removing JS from the classroom or from the school. That's the one part of the complaint where I wonder if you did enough on personal participation.
Yeah, so I think in a pre-discovery setting, we're obviously limited to information and belief. I think the complaint does allege that the decision to summarily and informally suspend JS, Judge Rossman correctly summarized the sequence of events that occurred subsequent to the Stepp family making its formal Title IX complaint. He was initially sent home from school altogether with only a sticky pad of instruction and then eventually confined to the library.
Where's the who part of it? I mean, that's my question. It seems like you're saying the district did this, but you've got a bunch of defendants on the hook right now.
Yeah.
And why should they be on the hook for this?
So with respect to that particular claim, the procedural due process claim, the Second Amendment complaint.
The removal from the classroom, not the segregation part of it, but the removal.
Absolutely, absolutely. The Second Amendment complaint alleges that initially, and I might get these dates slightly wrong, but in late August, the Stepp family initially contacted Superintendent Lockhart and Principal Anderson. They then coordinated a second meeting with those same two administrators, as well as at least Defendant Russell. The Second Amendment complaint alleges, again on information and belief, that the board members, including Superintendent Lockhart and Principal Anderson, made this decision in coordination. That's consistent with the allegation that it was Defendant Russell, who's one of the board members, who contacted plaintiffs after.
All right, so you're saying that the complaint says that these individual defendants in concert made the decision to remove JS.
That's absolutely right. And
right, we can study the complaint and follow up on that just to kind of keep the ball rolling. On your procedural due process claim, do you have a case clearly establishing that the segregation policy, not the removal, but just the policy itself, was a due process deprivation? In other words, I'm not asking about the equal protection claim, just asking about the procedural due process claim. Is there a case, Supreme Court or 10th Circuit, and what is it that would make that out to be a due process deprivation?
And so I think both in the interest of economy and candor, the most fair response is to say that we think our equal protection claim with respect to the segregation policy itself is our strongest argument, and that argument on which the law is most clearly established.
All right, but are you saying that you don't have a procedural due process case?
I think that the most factually analogous case with respect, again, to the policy itself, if I understand you, with respect to the policy itself and on the particular procedural due process question, I think the most closely factually analogous cases that we could probably point to would be Catoosa and Goss. And I recognize that those concern the decision to suspend a student in the absence of process. But I think that the general constitutional principles espoused there, that deprivation of educational opportunity must be occasioned by the minimum guarantees of the due process clause. And again, I'm quite eager to return to the basic question of the Equal Protection Clause with respect to the segregation policy, for the reason that I think the law is conclusively well established. And I'll certainly take the court's hint if it would prefer that I discuss those other of our.
I'll do more than a hint. So on the equal protection claim, as I understand it, it seems to be based on the segregation policy, but is it also based on how on how Mr. McClain treated?
That's absolutely right. So we
I
make.
mean, and I'm not talking about the claim against Mr. McClain. We can get to that because you got a separate equal protection. I'm talking about whether the treatment of the child in the classroom is relevant to the equal protection claim against
The other
school
defendants.
district defendants.
And my answer to that is absolutely yes. And I understand exactly the distinction that Your Honor is drawing. We have, with respect to equal protection, we have a claim that targets basically all of the appellants here without, in the absence of McClain. That concerns the promulgation, implementation, and enforcement of the policy. We have a second equal protection claim that targets those same defendants in addition to McClain. And I apologize, point of clarification, I said all of the appellants to the exclusion of McClain. It's actually with respect to the equal protection claim, it's to the exclusion of McClain and Blair and Bryant, those being the Title IX defendants. So our policy-based equal protection claim targets Superintendent Lockhart, Principal Anderson, and the board defendants. Our harassment-based equal protection claim targets obviously McClain, and then under an admittedly slightly different analysis, specifically with respect to direct or personal involvement versus acquiescence or deliberate indifference, on a slightly different theoretical basis, we state an equal protection claim against McClain, the board defendants, Anderson and Lockhart. McClain, obviously the factual basis for that equal protection claim is the pervasive sexual harassment of JS and gender bullying of JS. With respect to the remaining defendants, the basis of that harassment-based equal protection claim concerns their having received adequate and indeed ample notice, both of the invidious effects of the segregation policy itself and the pervasive and severe gender bullying and sexual harassment that McClain was targeting at JS, and thereafter taking no remedial action as would be appropriate under the circumstances. The former...
Is the board responsible, did you allege that the board is responsible for policy implementation?
We did. We also allege, again on information and belief, that each of the individual board members personally and directly participated, not just in adopting the policy prior to the outset of the 2022 school year, but additionally in ratifying that policy after they were provided with notice not just of JS and the Stepp families' mistreatment and complaints, but provided notice at the September 6th board meeting by a group of concerned parents who came there both to protest the policy and to particularly shed light and raise concerns about the way that McClain was targeting JS for with gender animus. Does that answer your Honor's question?
Yeah, I think so. I mean, we, as Judge Matheson said, we have to go back and study this very, very closely, but I was just trying to make sure I understood whether you were relying on the board members' legal status in your allegations to establish supervisory liability, or there was
Right,
you're
no.
also doing the personal.
Yeah, so it's not a
personal
respondeat
board
superior theory.
Yeah,
We allege they personally and directly involved themselves in the adoption, approval, and ratification of the policy itself, and that they also demonstrated what case law tends to refer to as deliberate indifference toward complaints and notice of JS's mistreatment by McClain in the classroom. I think...
Can I ask you, that's actually a good segue to this question. The defendants point to paragraph 51 of the amended complaint, and there the allegation, among other things, says that the JS didn't really understand some of the terminology that Mr. McClain was using, and so they think that helps them in their position. But in response to that, if you could, respond to that, but also, if we have to address that in clearly established law terms, what's your position?
Yeah, so this is obviously a novel argument. I think it's one that is out of step with equal protection analysis in general. There's certainly in the Title VII, and to the extent that the Section 1983 jurisprudence is borrowed from Title VII, there are elemental requirements for a sexual harassment-based equal protection claim. Those are, of course, that there's discriminatory harassment. The second, and I think this is where the appellants are hanging their hat on the issue that Judge Matheson refers to, is that conduct is unwelcome, and the third that is that it creates a pervasive and severe environment hostile to education. As I understand it, the appellants don't even challenge the first or third of those prongs. They only challenge whether the conduct was unwelcome. And the basis of that is that JS did not immediately understand the meaning of certain epithets and slurs that McClain used to belittle him in front of his classmates. I think, that it would be a peculiar interpretation of equal protection if under the clearly established prong, if the state actor was able to essentially insulate himself by using more syllables than his 11-year-old victim. And I think the unwelcome analysis in the Title VII context is entirely different. It's a question of whether or not the victim of sexual harassment is even aware of discriminatory remarks that were made in most instances outside of his or her presence. Here, there can be no doubt, and I appreciate that amount of time. I'd love to briefly conclude that remark. Here, there can be no doubt that the harassment of JS was unwelcome. He broke down in tears repeatedly in front of his classmates. He and other parents notified the Stepps of their concerns. The argument, and just quickly, and I want to be very brief, I appreciate this, in Doe v. Hutchinson and in so many other cases which clearly establish the basis of plaintiff's claims here, the court recognizes that even facially gender-neutral harassment, especially when combined in the context of other gender-specific harassment, can be the kind of stuff that creates a hostile environment. In general, the qualified immunity doctrine exists to protect errors in judgment by good faith state actors. What we're alleging here is that these actors did or should have known that segregating classrooms, harassing students is wrong. It's constitutionally impermissible. So we'd ask the court.
Let me ask you on the substantive due process claim against Mr. McClain. How can you rely on the Abeta decision for clearly established law when the court, in that case, ultimately didn't find a constitutional violation? Isn't our circuit law such that in that circumstance, the case can't be relied upon for clearly established law?
And so again, I think the most honest answer to Your Honor's question is that the Abeta is probably not sufficient to establish clearly established law on the substantive due process claim. I think much like Judge Matheson himself sort of intimated earlier, probably the fastest horse on our substantive due process claim is going to be that the conduct which we allege, which in its totality, and noting that almost every single case that disposes of a substantive due process claim on the basis of qualified immunity does so on the fully developed factual record at the summary judgment posture. Totality of the allegations on the face of the second amended complaint involve JS's relative immaturity, his very young age, him being entrusted to the care, supervision, and instruction of an adult male who, on the face of our allegations, motivated by subjective animus, one might say hate, one might say bigotry, intentionally and deliberately targeted him and bullied him at a period of his life that he himself, as the appellant's defense itself illustrates, at a point in his life that he himself, his sexuality, his gender identity is so nascent and underdeveloped that he has a difficult time even apprehending why an adult would both assign to him these sorts of epithets and also encourage his classmates to ridicule him along second lines.
You've got in count 4 substantive due process alleged against the school district and McClain. And of course, we're not talking about the school district at this point because we're on qualified immunity, correct? And then count 5, you've got substantive due process against the board members Lockhart and Anderson. Would you agree that the claim against Lockhart, Anderson, the board members, is different, really different in kind from the claim against Mr. McClain?
And do I understand, Your Honor, correctly, that we're talking specifically about the substantive due process claim?
Yes, substantive due process.
Absolutely. Those are different in nature.
Well, you were talking about totality of circumstances and so forth, and I'm thinking, well, wait a minute.
That concerns only McClain.
We have to take each defendant on.
Concerns only McClain, and in fact, and I would hate to misstate the record on this point, I don't believe that the substantive due process claims against the other appellants survived the motion to dismiss the district court.
Okay, you're right.
I believe it is only against
So this is the only substantive due process we're dealing with now?
On this appeal, substantive due process concerns only Mr. McClain.
Thank you for correcting you correcting me on that.
My pleasure, and unless the court has additional questions, we would just urge that it affirm the decision below.
Thank you, counsel. I think we're going to call it a day. We've given both of you a little extra time, and we appreciate the argument. There's a lot to digest here. Thank you again. The case will be submitted. The court will be in recess until tomorrow at 9 o'clock.